days list, but
ওই কারেকশনটা আমি একটু বলতে পারতেন। হ্যান্ড ওভার দিস দেখুন একটা সাপ্লিমেন্টারি বাক করে দিন।
It's a small correction, Lordship, a word.
সাপ্লিমেন্টারি বাক করে দেওয়া যাবে?
Okay. Grateful, Lordship.
Please wait. Yes, call the list.
Number 1.
Yes.
My name, missing my.
Oh, your name? Oh, it has been pointed out that the name of Mr. Shaha has inadvertently not been recorded in the order dated November 3, 2025. First up, it is recorded that on November 3, 2025, Mr. Kumar Shantanu assisted Mr. Shaha for the state. Let such order be rectified. This order shall form part of the order dated such and such. Yes, call the next matter.
My lords, in item number 2.
Yes.
My lords, in item number 2, in page 3 of the order, in the second para, page line number 8, it has been mentioned that the petitioner is required to deposit additional 15% of the deposit within
But
the
we have already
specified.
deposited that and we have already filed.
Yes, additional 15% over and above 10%.
Yes.
Yes, my lords, but there was no time specified for that.
My lord, we have already deposited, we have already filed the application.
Oh, you have filed?
Yes, my lord, we have already made the payment also. A
claims
challan
to-
has also been submitted to the office of the respondent number 3.
Then it's all right, my lord, my lord.
Yes.
And
And
secondly,
Mr.
my
Agarwal,
lord,
the learned advocate says that the amount has already been
Lord,
deposited and
because-
they have preferred an appeal.
Now it is complied, then it's
Even,
all
my
right.
lord, we have moved an in time application also
That
as
is-
a
Right,
liberty.
so I'm recording.
Okay, that is-
When you
that-
need to
that-
file the appeal.
I think, my lord,
My lord,
on the day the order was passed, day after that only we have filed
No,
the.
no, my lord, yesterday on 6th of
Yesterday.
November.
So
6th of
yesterday it
November.
was filed, so 6th.
Yes, my lord.
It was filed on 6th.
6th.
Yes,
All
my
right.
lord.
my lord, my name has also not been incorporated in the order, my lords.
That is the way.
It has this matter has been mentioned by the learned advocate appearing for the CGST authorities. First up, it has been submitted by Mr. Agarwal, learned advocate, that in the order dated 4th of November 2025, no time limit has been fixed for depositing the additional 15%.
Lordship.
First up, the learned advocate appearing for the petitioner submits that the additional 15% as directed to be deposit as a pre-deposit has already been deposited on November 6, 2025, and the appeal has also been filed on that date. First up, since the additional amount of since the additional amount on account of pre-deposit has already been deposited and the appeal has been filed, there is no necessity to make any further
Lordship.
observations.
Lordship.
There is no necessity to fix any further time limit for depositing
Lordship.
said additional amount. First a
Lordship.
paragraph. It is recorded that Mr. Such and such learned advocate assisted Mr. Agarwal on
Biswaraj Agarwal.
4th of November 2025.
Lordship, deeply obliged.
Much obliged,
My lord, I
Yes,
just need
obliged,
to
my
raise
lord.
one point, my lords. We have not filed appeal.
Yes, sir.
We have given them a letter along with the copy of this order and a pre-deposit challan to get it restored and for
Oh,
the.
sorry, because the appeal was already
Yes, my
filed.
lord.
Already
Yes, my
filed,
lord.
my lord.
Mr.
The order
Agarwal,
was
what do you
certified.
say?
Lordship, it is set aside now. How, what?
So I'm only recording that the pre-deposit has been deposited on such and such date.
Yes,
So
ma'am.
appeal,
Yes, ma'am.
appeal has already
If
been
Lordship,
filed.
if actually
So
necessary,
the-
we will
so
communicate.
the deposit has been made on 6th of November 2025 and an application has been
Yes,
filed.
my lord, an
Yes, my lord.
And
application.
an application has been filed for bringing on record such fact before the appellate authority.
Yes,
Yes.
my lord.
My lord.
ঠিক আছে?
Okay.
Much obliged, my lord.
Yes, item number 3, yes, Mr. Kundu.
My lord, the daughter of the de facto complaint missing. Subsequently, she recovered. Only my pair is my lord.
She has been recovered.
She brought to the police station and thereafter made a statement and she left. But no information has been given to me. My lord,
Lordship,
only my lord. Yes.
I would like to realize some documents I don't want.
What
to
happened?
disclose.
What happened?
No, Lordship, kindly look into the matter, Lordship. I don't want to discuss anything.
All right.
So far my instruction, my lord. She left her according to her will.
এবার মুখ খুললে একটু ঝামেলায় পড়বো তারপর
না না
আমি চাইলে-
মুখ খুললে ঝামেলা।
মানে একটু বাজে allegation।
লিখে দাও।
Why she left her matrimonial house, Lordship? Hope now Lordship will understand. And she is ready to come before Lordship in virtual mode, Lordship, if Lordship will allow. Now she is preparing her SSC, Lordship, and she has already completed her double MA.
Do serious allegation against.
Yes, that is why I don't want to disclose, Lordship.
Serious allegation against your client.
If Lordship will give the permission, yes, I will contact with the police personnel, then she will appeal virtually. For the satisfaction of the Lordship.
Then they giving any information
She
regarding.
don't want to disclose her address,
It
Lordship.
has
She is
been
a,
your-
Serious allegation against you, against your client, and
mother and
she is
husband.
a major person.
Yes, major
Yes.
person.
He is
Where
not,
she resided.
he is
my lord,
not missing. So, so on the basis of the complaint, FIR has been registered.
No.
No, Lordship. One GD has been registered and on the basis of the said GD, Lordship, police conducted raid, and after that, this matter come to our knowledge, Lordship.
All right. So you can only communicate.
Yes.
Because she don't want to disclose her
No,
address
don't
also.
disclose anything, but that on the basis of the complaint that you have not decided not to only disclose that. Please communicate.
And Lordship, we have registered, that is in our report already mentioned in the first paragraph, Lordship. We have registered a missing person case number. After that, we have closed that one.
Oh, you have registered.
Yes, Lordship. This is the missing person case number 173/2025, dated 9/5/2025.
Yes, missing person case. So you have done, you have taken
Yes, Lordship.
steps.
Yes, Lordship. And it was closed after that. It is also, we have mentioned in the second.
Second paragraph.
Yes, Lordship. First paragraph, last line, Lordship. FIR number
So,
one.
you have disclosed that.
Disclose. my lord,
So there is no
communication.
necessity to further intimate them.
My lord, where she reside, my lord, if is there any incident.
For her safety, Lordship,
Lord-
she is in a safe custody. She is
she
A
is
major
residing with
person-
The
another-
way you took care of your daughter, don't need to take her information as it appears. It's an unusual case. Ashun, this application,
After 5 months, they disclosed. Before that, she
They
she
know
was not
missing,
disclosed nothing.
sir, she was not missing. She was not missing.
But some information was given.
Already-
some
What information you want?
Where she deciding which
If the relations improve, you will get everything. And
She
before
automatically get
leaving,
back.
she gave you information that she is leaving.
Yes.
That's a
Yeah.
statement. And how she gave
This-
information, that has also been recorded. I'm not disclosing anything, so your
And she is
client,
ready to
your
come. with
client knows
Bharti
everything.
Lordship.
You may not be knowing, but your client knows everything. The petitioner has filed, no, the petition has filed. The petitioner alleges that the police authorities have not taken any effective steps to register a specific case against the আচ্ছা, তার আগে লিখুন। The petitioner alleges that the
paragraph 3 note.
paragraph 3,
Yes.
petitioner alleges that the married daughter of the petitioner was missing on and from May 8, 2025, and a missing diary was lodged on May 9, 2025 by her son-in-law before the Kotwali police station, Jalpaiguri. Full stop. The petitioner suspected that some persons forcefully restrained the daughter of the petitioner and filed this writ petition alleging that the police authorities have not taken any effective steps to register a specific case against the accused persons and also did not take any steps to recover the daughter of the petitioner. Full stop. When this matter was taken up on November 6, 2025, the learned advocate appearing for the state prayed for an accommodation to take complete instructions with regard to the allegations made in the writ petition.
Lordship, one CD is there annexed with the report, Lordship, for Lordship satisfaction.
Do one thing, file it in a sealed cover.
Lordship.
Only file the report in a separate and the other documents in a sealed cover. That will be detailed. The learned advocate appearing for the state files a report of the inspector in charge, Kotwali Police Station, Jalpaiguri, dated November 2, 2025. First up. It appears from the said report that on the basis of the written information received from the petitioner, the information was registered by Kotwali PS GT entry number 821 dated 9/5/2025 and missing person case number 173/25 dated 9/5/2025 was started and the case was endorsed to an ASI for investigation. Full stop. In which paragraph you have stated that you could contact where? In which paragraph?
Lordship, in second page, 1, 2, second paragraph. Missing lady Moshumi Burman was contacted and was
The report specifically
and Lordship
gives the
kindly,
details and particulars.
and Lordship, in the same line in the top, Lordship, you can see that she even sent a video stating that video clip we have annexed.
Where?
In the second page, top.
Second page, top.
Her address, first her address, after that.
The
And we have already
the said report further states that the concerned officer made communications through the mobile phone number of the daughter of the petitioner, and the daughter of the petitioner responded to the communication, and she stated that she had left her house on her free will and has also disclosed to such officer the place where she is now residing. Full stop. The report further states that Mr. Kundu, learned advocate appearing for the Mr. Kundu, learned advocate appearing for the petitioner submits that the daughter of the petitioner was forced by the police authorities to make a declaration before the police authorities. First up. The report paragraph. This court is not inclined to accept such submission of Mr. Kundu, as the report states that the married daughter of the petitioner had sent a video stating that she is safe and sound, and the copy of such video has been enclosed along with the bunch of documents filed with the report. Full stop. The report specifically states that states about the qualification of the married daughter of the petitioner and what she is doing at present and where she is presently residing. Full stop. The declaration given by the married daughter, where is that? Which page?
Lordship, that is in second last page.
Oh, yes, absolutely. The declaration given by the married daughter of the petitioner has also been produced along with the documents annexed to the said report.
And Lordship, that documents has been, we have registered that declaration as being GD number 2212 dated 28/10/2025.
First of the said declaration has been registered as GD entry number 2212 dated October 28, 2025. Full stop. After going through the in the said declaration, it has been specifically stated by the daughter of the petitioner uh, na, uh, in the said declaration, serious allegations has been leveled by the daughter against the mother petitioner as well as against her husband. Full stop. It has also in the said declaration also states that she is residing independently and pursuing uh, uh, and independently. Full stop. Paragraph. The the assistant court officer is directed to keep the records produced by the to keep the report as well as the documents annexed thereto in a sealed cover, which is to be retained along with the records of this case. Full stop. Paragraph. The report concluded by stating that the inquiry conducted revealed that the missing lady, namely the missing lady, left her home to pursue her career, and she neither went missing nor was held captive by anyone. Rather, she took decision of leaving home due to continuous torture by her husband and especially her own mother. Full stop. For such reason, this court is not inclined. After going through the said report and the documents annexed thereto, this court finds that the police authorities have taken prompt and effective steps on the basis of the complaint lodged by the petitioner, and full stop, the writ petition is devoid of any merit. Full stop. Accordingly, the same stands dismissed.
Deeply observed.
Yes, এটাকে না সিল কভারে রেখে দেবেন। এটাকে সিল কভার সিল করুন, করতে বলুন, করিয়ে দাও। না রিপোর্টটা না সব শুদ্ধই রেখে দিন, কারণ রিপোর্টেও সব রয়েছে, দি এন্টায়ার থিং। Yes.
I beg to appear for the petition virtually.
Yes. Yes.
My lord, I directed the state to bring on the notices, my lord.
Yes, yes, Mr. Pal, what is it?
Right, capable of the petition, but paucity of time.
Yes.
They have sent me only a report.
Yes, give me the report. Yes, they have said that it has been acquired and you have not received the award was declared, date of declaration of the award, everything that has been disclosed. If you are aggrieved, you challenge those proceedings. Ashun.
My lord, my submissions are, my lord, they have not given a notice to me, my lord, so
All
that
right,
I can
so you
participate.
have to
My
challenge
lord,
now.
my
Sir,
lord, kindly
only your
grants me
allegation
an
was that,
exception.
sir, your allegation was that without taking any steps. Now the state
My
has
lord,
disclosed some information.
my
You
lord, but
challenge
that,
those
my lord,
proceedings.
my lord, but that
Now,
information
your
was
case
never
was
served
not
to
that
me,
it
my
has
lord.
been acquired without following the procedures. Your
My
case
lord, they
was
have,
that it
if my
was
lord, if I have not been heard, my lord, if
all
notice is
right.
not served to
You
me,
challenge,
my lord, then
sir.
it is not the due process of law. My lord,
Sir,
kindly
I'm
gives me an
giving you.
opportunity to take an exception to
I'm
this
giving you
report, my lord.
liberty. You file a fresh application with better particulars. Now you have got some particulars. The petitioner has filed this. No, the petitioner claims to have purchased land being plot numbers 148 and 151 pertaining to Khotian number 653, jail number 99 within Moja Dokkin Bagdogra in the district of Darjeeling near Bagdogra International Airport. The petitioner claims to be operating a hotel under the name and style of Messrs. Sunita Hotel, which is situated on the aforesaid plots of land. First up, petitioner claims to have made construction of the hotel after the character of the land was converted from Rupni to Bastu by the concerned authority. First up, the cause of action for filing the writ petition is that on October 31, 2025, certain officials of the Shiliguri Jalpaiguri Development Authority, bracketed SJDA, accompanied by certain police personnel, came to the petitioner's hotel and directed the petitioner to vacate the premises within November 3, 2025. First up, petitioner alleges that no notice to such effect was provided to the petitioner. First up, yesterday, that is on 6/11/2025, when this matter was taken up, the learned advocate appearing for the SJDA authorities filed certain documents in support of their contention that the plots in question were subject matter of land acquisition proceedings initiated in the year 2005-2006, and an award has been published. First up, it was further stated in the কি বললাম কি বলে শুরু করেছিলাম these SJT authorities when this matter was taken. আচ্ছা, the said document also from the said document it was recorded that the name of the petitioner appeared in the list of the awardees, but the petitioner did not receive the compensation amount. First up, the matter was adjourned to enable the state to file documents. First up, today when this matter is taken up for hearing, Mr. Shah Laner, additional government pleader, assisted by Mr. Pal, appears and files a report of the Special Land Acquisition Officer, Darjeeling, dated November 6, 2025. A copy of such report is taken on record. First up, from the said report, it appears that the land of the petitioner measuring about 0.01 acres was acquired wide LA case number 3/4 of 2005-06 wide notification dated October 28, 2005 for construction of cargo complex, and the award was declared by the collector on April 9, 2009, and the name of the petitioner featured in serial number 9 of the award list was featured in serial number 9 of the award list, and the compensation amount was rupees 2,65,117 only. And further land, and the other land measuring about 0.059 acres of the petitioner has also been acquired in the same year for construction of multi-utility facility for Bagdogra Airport in LA case number 4/4 of 2005-06 wide notification dated October 28, 2025, and the award was declared on February 26, 2009. First up, the report further states that in respect of the said plot, the name of the petitioner appeared under serial number 4 of the award list, and the compensation amount was rupees 12,721 only. First up, the report further states that the petitioner has not received the amount of award compensation, and the same is still lying unpaid. First up, the learned advocate appearing for the petitioner submits that that no notice of the acquisition proceedings was served upon the petitioner. First up, this court is not inclined to entertain such a plea in the basis such a plea in this writ petition, as the writ petition was based, as the cause of action of the writ petition was only that the SJDA authorities had come to their property and asked them to vacate. First up, in view of the fact that the it appears from the documents filed by the state and the SJDA authorities that the land of the petitioner was the subject matter of 2 land acquisition cases, and which culminated with the passing of the award. Full stop. It is well settled that with the passing of the award, the property stood vested upon the state. Full stop. If the petitioner is aggrieved by if the petitioner feels aggrieved for non-payment of the compensation amount, or for
My submissions, my lord, is like we have never known the subject matter of these proceedings, my lord. We were never intimated. It was outside our knowledge, my lord.
Now, for such reason, this court is not inclined to grant any relief to the petitioner on the basis of the averments made in the writ petition. First of it will be open to the petitioner to take appropriate steps in accordance with law. With the above observations, WPA number such and such stands disposed of. Yes, next.
Great, Kumar.
One correction is there. Small correction. What is this correction? Should be?
Should be Shakti Bari, instead of Shakti Bari.
Oh, instead of N, it will be R. Yes, that is the only correction. The learned advocate appearing for the petitioner submits that in the first page of the order dated November 3, 2025, the name of the school was wrongly recorded as Poschim এই শব্দ বাণীটা না বাড়ি হবে এই এনটা শুধু আর হবে ঠিক আছে instead of such and such let such error be rectified this order shall form part of the order. Yes, next.
My lord, in this matter, my lord, I am representing the states, my lord.
Yes.
My lord, I would like to invite your lordship's kind attention. The order dated, my lord, past 18th September 2025, my lord.
Yes.
Yes, my lord. My lord, actually, they have challenged that the tender process, which the petitioner was unsuccessful with regard in the technical bid evaluation process, my lord, because he is not qualified with regards to the requisite qualification has been sought for in the NIT. So, my lord, in the first occasion, the 18th September, the matter was taken up. My lord, there was 2-3 challenges by the writ petitioner, my lord.
Yes.
In this regards, my lord, a report has been, my lord, we even intended to file a short report.
Yes.
And the next date when the matter was taken up on 24th September, my lord, there was a huge waterlogged, my lord, in Calcutta, my lord. So we could not reach in time. So anyhow, if you
Oh, this was taken up from the principal.
principal bench, my lord, during the off-circuit my lord,
Yes.
period. So, my lord, if your lordship see the 18th September 2025, my lord, the order.
Yes. So there was an interim order passed.
No, my lord, interim order, my lord, paragraph 12.
Yes.
Paragraph 12 that it is expected.
Will
that the
not be issued prior to the returnable date.
So returnable date was, my lord, 24th September 2025.
Yes.
Report was submitted and my lord, it could not be filed because and formal report to be filed before this honorable court, my lord, report is ready and it has been circulated to that. In 24th September 2025, it was a direction that the exception, if any, to be filed, my lord. Paragraph 4, my lord, 24th September 2025. Lord, you kindly see. So there is no, as of now, there is no exception of the report which we have filed, my lord. We have circulated.
You have circulated.
Yes, my lord. Yes, Lord, you kindly see that.
When have you circulated?
Huh?
When have you circulated?
To the learned advocate.
When?
23rd September.
Yes, Mr. Mr. Why have you not filed any
No,
exceptions?
we will
to
not
the
file any
report?
exception. We will straight away argue it.
So very good.
We will straight away argue it. No, we do not need to file any exception because
So
we
I'm
have seen the
recording-
report. We
I'm
have seen the
recording
report.
that you don't need to file any exception. That
Very
you will
good.
not file any exception.
Then, my lord, my lord, undertaking was given. Effectively, my undertaking is given that, my lord, paragraph 12. So, my lord, that to be, my lord, if the lordship takes up, very good, my lord.
Today, Mr.
My lord, then
Chaudhary,
this arrangement cannot be made, continue.
Mr. Chaudhary, I am keeping it just, I'm
lord,
keeping
my
it
lord, kindly see-
returnable on the next day, first day of the vacation. Because
My lord,
today,
my lord, kindly appreciate. This is, my lord, the tender process, my lord. Generally, the read code do not interfere unless it shows this is a complete malafide, my lord, or any, my lord, the bias, or my lord, the other reasons which tended to that the tender was not awarded.
but Mr. Chaudhary, only one thing. An interim order was rightly or wrongly passed.
No, it is-
18th of
can it be-
September, 18th of September 2025.
Right, lordship.
Today we are on 7th of
Well,
November. So I'm keeping it 17th, it will
Well,
start. I'm retaining this matter in the list. I'm
Then,
taking your,
my lord, kindly see one aspect, my lord. What is the tender requirement in the tender document in ENIT, my lord? that this is a
We can argue-
heritage commission's my lord to work
We can argue, finish it up.
for a restoration of a my lord the Graham's home, my lord. So in the
Restoration of
Graham's home at my lord Kalimpong by the Heritage Commission, my lord, because it is now a tilted, my lord. At any day it may fall. So this is the reason the partially part wise, my lord, this process has been initiated. Work order has been separately issued. 2 phases have already been completed. This is the 3rd stage. So, my lord, in the ENIT, my lord, there was the one essential qualification that the same nature of work has to be carried out, or equivalent work carried out under the same government organization. So, my lord, he hasn't performed any such equivalent nature of work with regards to the said tender conditions, my lord. He has provided to my lord, the completion certificate, which is also listed to the Heritage Commission, but that was not undertaken by the Heritage Commission, my lord. That was, my lord, in Sirampur, Mashirbari of Jagannath Temple and Hugli Chandan Nagar, my lord. So, my lord, from these 2 documents, if your lordship compare, then the such equivalent work he has not carried out or my lord executed at the point of time.
those are on merits. Those are on merits because he has also to be hard. And if it was taken up before, situation would have been otherwise. Now I'm keeping it on 17th. I'm extending
But 12,
this.
12, paragraph 12.
I'm extending
My lord,
this,
can it be? I am asking myself. Can it be an interim order, my lord?
Mr.
Paragraph 12 is in a.
I will
Then why are
extend
you
it.
opposing it?
Mr.
I am
Addition-
using this paragraph 12 should not be coming to force while executing this my lord tender work.
But I cannot go into that. Being a coordinate bench, when an order has been passed, not challenged.
Yeah, then, my lord, in the why he has chosen in the last day, my lord, for under the heading of extension of interim order, my lord.
Why didn't you
My
appear
lord,
on
why
24?
I made an effort, my lord.
No. This was mentioned
Mr.
before, my lord.
Additional Advocate General, now I am doing one thing, I am restricting it to a particular day in the next circuit. So
Look,
that you get your opportunity, and if it does not,
my lord, it is also there for a restricted day. My lord, kindly see the last.
no, till the next date of hearing, it has said.
No, my lord.
Yes.
My lord, it will be open, my lord.
To file an exception, it is
Yes.
expected, issued prior to
No,
the
my
next
lord.
date of
In
hearing.
view, paragraph 3. In view of the aforesaid submission, hearing of the writ petition stands adjourned till 4th November 2025 of the circuit page at Jalpaiguri. Today, my lord, we are in 7th. So it is there is no such paragraph 12 cannot stand on the way, my lord.
No, my
Mr.
lord. It's mentioned-
Mr. That's right.
It was mentioned before, my lordship. It couldn't be taken up.
Where is the-
It was
You have
mentioned
not
twice.
said, Mr. Mishra, you have not said under the heading extension of interim order. All
It was said
extension
that
of-
as per the previous order, it was to be listed on 4th. It couldn't
But
be
you have,
listed on 4th.
No
that's-
application is
that
filed.
is the other way of looking at it. You have not mentioned, because yesterday you have mentioned for extension of interim order, I have kept it under the heading extension of interim order. What prevented you from making that submission on 3rd?
Or on the day of
You
27th.
have not done so.
Lords, even the copy of the order
Specifically,
was,
Mr. Mishra, I am
even the
maintaining
copy of the
this
order was along with
extension
the
of
mentioning
interim
slip,
order.
Lords.
Once it is mentioned, those are listed on the next day.
And has to-
Purposely, you have not mentioned.
Extension
No.
has to be
I
on
do
the
not
merit,
get
my lord.
benefited by that, Lords. It can be taken up for hearing now and here itself.
Mr.
It's
Mishra,
a hearing.
you are very well know, in the last day, it's very difficult to hear this matter.
Lords,
Very
had it been
difficult
not
to hear
because of
this
the
matter.
interim order, Lords, even I would not have mentioned it, Lords. It was because I already have an
Interim order expired on
protection,
4th.
Lords.
I will
It was
record.
mentioned on 3rd.
Yes,
It was
yes,
mentioned.
Mr. Mishra, it was before the last returnable date, it was on 4th.
It was mentioned before, my lordship, on 3rd, my lords. To be included in the list
My
on
lord, what is the
4th.
CAN application? Where is the CAN application? If the extension has to be on merit, my lord.
Mr. Chaudhary, I'm extending it
My lord,
till 18th.
my lord,
Till 18th.
my folded hand, my lord. This is my lord, the public work. My lord, kindly appreciate, my lord, my kindly
Mr.
see.
Chaudhary, for 1 week. It is continuing from September. I'm
is
extending
no-
it specifically. I'm not making it vague. I'm not making it till the returnable date. I'm specifically extending for a particular day. If it's not,
My lord,
it's
in
not
absence
extended.
of, I am asking the absence of any application. In absence of application, the interim order which stood vacated. Can your lordship and your lordship know very well?
Mr. Chaudhary, the other way is,
Yes, my lord.
there was a direction that this matter
Yes.
will
Be listed
appear on
on
4th
4th.
of November.
It
So
didn't
it's the
appear.
court's fault if you look it at the other way. It's the court's fault that
I
this matter did
understand,
not.
I understand. If they then ought to have filed an application for extension of the order
Mr.
which passed.
Chaudhary,
But there is no
if
such application. They said that I will not file an
filing of
exception.
applications in a pending matter,
Malad,
only
they-
one, two,
but
three
Lordship
says.
knows that every interim order for an extension
Is valid
requires
6
to be
months.
Malad on its merit, on its own merit.
Yes, yes. That
That was a situation arises that in absence of a detailed report, the honorable court found, and on the basis of my undertaking, I should not be deprived.
So,
So, Malad,
I
this
could have
situation
considered this matter. If it was some days before.
Malad,
Only difficulty is it is on the last day.
no, Malad, that is true, last day. He has chosen.
That you can
Malad,
say
in
that
this
yes.
way, when there is no interim order, imposition of interim order afresh, that should be tempered.
Asud,
Nice try.
I'm recording your objection.
No, it's a question of you should not laugh. This is a place to laugh even.
No.
No, this is not place to laugh even.
Are you?
No, this is not
should have become
sarcasm.
serious in
No, this is
everything.
not a sarcasm.
Sir, if I started when you finished.
Advocate,
I didn't
you
even
are-
disturb you while you were making the
Isn't
submission.
advocate, why are you getting agitated? This
No need.
past,
Nothing is
side
personal
comments
here.
will come.
Everything is client based.
Side comments will come. Why are you getting involved in that?
He's a seasoned person.
File your report. File your report.
Today he is filing the report. He wanted me to file the exception even
Malad,
before the report is
again,
filed.
Malad,
Mr. Mishra, the copy was handed over to you.
Yes, my lord.
The under
I said I
exceptional
will-
circumstances, he could not file.
I said,
If
Milord,
you
I will
take
not-
that point, I will not
No,
extend.
Milord, I'm not filing the
If you
exception.
take
The
that
report-
point, I will
I
not
will file
extend.
this report.
On that
I will
particular,
go by the report, Milord.
on that particular day, everything got derailed
My lord.
in the
even
principal
I
bench.
Even I landed Milord at 11:30. I could not reach at 11. My flight was there. I had my Mr. Pal even put up both tickets were there. We are cancelled. Then again, the first day we took a flight, landed at 11:30.
That was an exceptional day.
I understand. Although I was
Everything
there
got
in the
affected on that day. So don't take that plea that
No,
he has not filed. He has circulated you. So you could have filed your exceptions on or
No,
before
I have
that.
gone through the report. We do not need to file
That is a different thing altogether. You are taking this objection. Filing is, it's upon the court whether to accept it or not on a particular
No,
day.
definitely.
It is nothing on you when the copy has been served upon you.
The person with the honorable court order, I am filing this report because
Yes.
to be filed before the
So whether the
honorable
court will accept it or not is absolutely up
No,
to
no,
the court
I-
when the copy has been circulated to you.
I'm not on that.
This matter was mentioned yesterday for extension of interim order. Full stop. When this matter is taken up for hearing, Mr. Mishra, learned advocate appearing for the petitioner, praised that the interim order which was passed by this court on September 18, 2025 and subsequently extended on 24th of September 2025 be extended further.
I would rather say it's not, it is an
No, no, my submission, my lordship, is recorded.
This submission I'm recording. Be extended, full stop. Paragraph. The prayer for extension of interim order. Mr. Chaudhary, please hear this. The prayer for extension of interim order is seriously opposed by the learned additional advocate general. Full stop. He submits that
This is an arrangement, not an interim order.
he submits that no interim order was passed by the court on September 18, 2025 and on the basis of the submission made by the learned advocate representing the state respondents, the coordinate bench observed that it is expected that the work order will not be issued prior to the returnable date. Full stop. He further submits that the petition, that no attempt was made by the petitioner to get the matter heard during this circuit and on the and has approached the concerned bench for extension of interim order on the very last day of the circuit. Full stop. The learned additional advocate general further submits that the that due to the waterlogged situation at Kolkata on 24th of September 2025, the though the learned advocate for the state appeared through virtual mode but could not attend the court physically to file the report as directed by the order dated 18th of September 2025. First off, he further submits that a copy of such report has been circulated to the learned advocate for the petitioner on
23rd September.
23rd of September 2025. First stop, the copy of the report filed by the state देखिए reported date টা দেখি।
That is 23rd.
Copy of the report of the superintending engineer NBCC-Roman 2, PWD Jalpaiguri, dated September 23, 2025, filed by the learned advocate for the state is taken on record. First stop, Mr. Misro, learned advocate appearing for the petitioner, submits that the petitioner shall not file any exception to such report. Such submission of Mr. Misro is placed on record. First up, due to paucity of time,
Paragraph 3 of this 24th September, the interim order stands vacated.
the learned additional advocate general submits that the interim order stood
This constitute as an interim order.
submits that even if the order dated 18th of September, even if for argument's sake, it is accepted that that an interim order was passed by an order dated, was passed on September 18, 2025, the same stood vacated in view of the observations made in paragraph 3 of the order dated September 24, 2025. First up, he submits that no application for extension of the interim order / arrangement has been made by the petitioner. First up, however, the fact remains that by an order dated 24th of September 2025, the hearing of the writ petition stood adjourned till November 4, 2024, before the circuit bench at Jalpaiguri. Full stop. The matter did not appear on the returnable date. Full stop. A litigant should not suffer due to the fact that the matter was not listed as directed by the order dated September 20. September 24, 2025. Full stop. However, considering the nature of the work under the tender in question, the interim order passed on 18th September 2025, which was subsequently extended on September 24, 2025, is reimposed as on this day and shall continue till November 19, 2025. Full stop. List this matter under the heading. It was under what heading?
Extension of interim order. Under the heading, it was motion.
Under the heading motion, list this matter under the heading motion on November 17, 20.
If it is written in the list,
It will be written in the list under the heading extension, then I have no difficulty, I can keep it under the heading extension,
yes,
if you want.
no. Let it be listed on 19.
17th, this
17th
matter will
matter
appear,
is listed.
entry order is till
19,
19th.
19.
The first day of the circuit.
Yes, matter will appear on the first day.
Yes.
And এটা লিস্টেতেই করে দেবেন মোশনে মোশনেতেই 17th যেন লিস্টে না
Grateful.
I'm different.
Sorry, Miller, my little hesitation. I'm sorry, it's my planet bend even. Generally,
No, no, it's
it is not hesitate.
We are.
Item number 6 to 9, service has not been affected. Applying for next year.
Yes, what is this matter?
Matter is about the respond authority number 4 intended to acquire my land for laying pipeline. But they have not given any notice of acquisition, not given any compensation, not reply any.
Who is the appropriate authority?
Appropriate authority is the Special Land Acquisition Officer, Jalpaiguri.
Special land, yes, Mr. Pal.
Okay, fine. Okay, what's it? Next circuit handling. Sir, fine, police.
You have an extra copy. Give it to him.
Right now, I have one copy. Yeah.
Supply it in course of this
Yes.
day. It's a acquisition matter. Consider, he has made a representation, consider and pass it on. Please give a,
Our appearance may be.
yes. Please give a copy to them in course of this day.
Doctor, 6 to 9 are similar matter.
All right. You are the recorded owners.
I am the recorded owner. I have annexed the document.
Your property has been acquired.
I have not informed, but they are not taking measurement of my property,
Kindly keeps it next surface.
setting up machinery,
Take instruction and come.
I think it's better.
setting up machinery. We have no.
6 to 9. একই order হবে. The learned advocate appearing for the petitioner submits that the service of the writ petition has not been effected upon the respondents. Post of petition is directed to serve a copy of this writ petition upon the respondents and file an affidavit of circuit as affidavit service on the next day. Post of list this matter before the next available. 6 to 9 same order. Next. He wants to serve, let him serve because it takes time. Yes, who is appearing?
Lordship, I'm praying for next circuit.
You have served or you have not served?
Lordship, I don't have any information. I have just received the information
On
from
the
the.
prayer of the learned advocate for the petition, list this matter before the next available circuit bench. Yes, next.
Item number 11, my lord, copy has not been served, my lord, service not completed.
What have you prayed for?
My lord, I am not reported on record, my lord.
On the prayer of the learned advocate for the petitioner, list this matter before the next available circuit bench. Post of petition is directed to serve a copy of this writ petition upon the respondents and file an affidavit service on the next day. Next.
My lord, item number 9.
9, you have been served.
Yes, my lord, it was served yesterday, my lord. And the returnable date is on 17th.
Yes, I've said it in the next circuit. Yes. 12.
12 minutes, the answering response is Darjeeling municipality, it is not served.
Darjeeling.
Yes.
What is this matter?
Very illegal construction.
Illegal construction,
Yes.
municipality.
Municipality themselves have served the order For demolition back in
Uh,
2023, then silent.
Since service has not been effected, this matter before the,
Let it be on 17th itself.
list this matter before the next available circuit bench. Petition is directed to serve a copy of this writ petition upon the respondents and file an appeal service on the next day. Yes, next.
Lordship, praying for next circuit.
Copy served or not served?
We have served, but the return date is 17 November.
Today only I have the big Lordship.
What have you paid for?
17 Lordship.
I am not advocate in recording, Your Lordship.
Oh, I'm sorry, I was in courtroom number 3. Yeah, my lord, there's one thing I'm sorry, because in the presentations, what I've been told, today's date has been given.
Yes.
But when it was served, my lord, not there, it has been stated to be.
What have you paid for?
My lord, first and foremost, this is my lord, otherwise, case to be filed before the administrative tribunal. Now, my lord, I have stated that since the tribunal is not functioning,
Not functioning?
no, none of the presiding officers are there now.
All right.
Here, my
What
lord,
do you want?
I had, my lord, during my service for medical treatment, applied for commuted leave. When I retired, took voluntary retirement, that commuted leave was not granted completely, it was given half earned leave.
So wrong calculation according
Yes,
to
yes.
you.
There is a representation pending before.
Executive Engineer Jalpaiguri.
Yes, my lord.
You are representing Executive Engineer
Yes,
Jalpaiguri.
But today I
Cons-
have received
Consider this and dispose
in
of.
accordance with the Lordship.
Grateful, my lord.
Ashun. The petitioner has
Number 13, I am for the state.
হ্যাঁ তোর নাম দিয়ে দিচ্ছি
The
থাম
matter was served yesterday and returnable date is on 17th month.
all right, all right. The petitioner has paid for recasting the leave account sheet within bracket leave statement of the petitioner and to disburse the balance amount on account of commuted leave.
Commuted leave.
On account of commuted leave. Full stop. The learned advocate appearing for the petitioner, comma, in his usual fairness, comma, submits that the petitioner has approached the writ court as the administrative tribunal is
Stated.
state administrative tribunal is not functional at the present moment. Full stop. Since the petitioner such submission is not opposed by the learned advocate for the state. Full stop. Since there is no alternative efficacious remedy for the petitioner at the present moment, this court is inclined to take up this writ petition. Full stop. Paragraph. The petitioner has submitted a representation before the Executive Engineer Jalpaiguri Division Public Health Engineering Directorate, praying for disbursing the balance leave salary. Praying for disbursing the amount on account of balance leave salary after recomputing the leave statement. Full stop. The learned advocate appearing for the petitioner submits, though a representation dated 24th of April 2025 was submitted, but till date, no decision on such representation has been communicated to the petitioner. First paragraph. The learned advocate appearing for the state submits that if some time is granted, the said respondent shall communicate its decision to the petitioner. First up, in the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of. Stands disposed of without entering into the merits of the claim made by the petitioner in the representation dated April 24, 2025, and by directing the
respondent number
Four, my lord.
the Executive Engineer, Jalpaiguri Division, Public Health Engineering Department, being the fourth respondent, to consider the representation of the petitioner dated April 24, 2025, which is annexed at page 28 of the writ petition, and to dispose of the same in accordance with law after giving an opportunity of hearing the petitioner or our authorized representative, and to communicate to pass a reasoned order বলেছি তো? By passing a reasoned order after giving an opportunity of hearing, ঠিক আছে? And to communicate the reasoned order to the petitioner immediately thereafter. The entire exercise shall be completed by the said order along with a copy of the representation dated 24th of April.
Grateful.
Grateful, Lord.
Call the next matter.
My lords, I appear for the petition. My lords, this is an income tax matter. Yesterday it was taken up. Here the only innocuous prayer is that I want to file an appeal, my lords.
Lordship, Lordship,
What?
but my instruction is double PAN card theory, your Lordship. They prefer trying to file an appeal against the PAN card which was surrendered, your Lordship. In the same name, two PAN card they obtained, your Lordship. Now one PAN card, after assessment, they surrender. Now automatically the PAN card is locked. There is no OTP and others. Now your Lordship, they want to file the appeal against the surrendered PAN card. That's the problem.
Against
I have
the
an
surrendered
instruction.
PAN?
May I submit?
I have the instruction to file an
No,
affidavit.
so
There
there
is
are
a
two-
factual dispute.
There are two PANs.
Two PAN card.
My lords, what happened was initially I was.
No, what happened? One is surrendered. What happened to the other?
Other
That has also become inactive as per my.
No, my instruction, second PAN card is active. OTP generated is all the okay.
So you can file the appeal.
Against the surrender PAN card, your Lord.
My lords, the bond is there in the first PAN card. My lords, what happened was.
Which has been surrendered.
Yes.
Let them file affidavits then.
Yes, Lord.
My lords, unnecessary, this will take.
That has instructions to oppose one way. One way is if they are agreeable, I can direct you to file appeal. But on this
That
fact,
was
there
my
are-
only limit.
no, so I agree with your submission
But
that
one thing
you
is
cannot be remediless.
Yes.
Either before the appeal or in the writ court. In the writ court, he wants to file affidavit. I am entertaining this writ. So let him file affidavits, it will be decided.
But what I was submitting, my lords, my only prayer was that I am not even challenging the order here in the petition.
Sir, according to him, that cannot be allowed.
Very well.
You have surrendered. That's his submission. That you are not entitled to file an appeal on the basis of a surrendered PAN. That's his submission.
What
So
happened?
that has to be decided.
What happened, my lords, I had given them a letter in 2022. Subsequently, reassessment proceedings were conducted in that.
Those are on merits.
Yes.
Now you have surrendered. It's not that their action. So it's you have surrendered. Now you want to prefer an appeal on the basis of that surrendered PAN card. That's the difficulty. So that's the legal issue which arises.
Very well.
Which order you want to challenge?
My lords, I am not challenging the order. My
No.
prayer is for
You want to prefer an appeal against which order? You
Yes.
wanted to prefer an appeal.
assessment order is at page number 27. 3 orders I want to prefer an appeal. 27 is the assessment order and 26 and 41 is the penalty order. Consequential penalty has also been imposed.
27 is the assessment order.
Yes, my lords.
And
36 and 41 are the penalty orders. And my prayer is there at page number 19.
36 and 41. Forty-one is the penalty. What is 36?
36 is also penalty order, my lords, 36. 272A 1D. My prayer is at page number 19. B.
Oh, here you have specified the
Yes.
orders. Petitioner alleges that the petitioner is not being allowed to prefer appeal against the assessment order dated February 29, 2024, semicolon, the penalty orders dated June 25, 2024 and September 20, 2024 through online mode full stop. The petitioner prays that a direction be passed upon the respondent authorities to allow the petitioner to file the appeals against the aforesaid orders physically. Full stop. Paragraph. Mr. Singhania, learned advocate, appears for the Income Tax Department. Full stop. He submits that appeals can be filed only through online mode and physical filing of appeals is not permissible. So he further submits that the petitioner was having two permanent account numbers and one of such permanent account numbers has been surrendered by the petitioner. He further submits that the petitioner intends to prefer an appeal on the basis of the wants to prefer an appeal against the assessment orders passed in respect of the permanent account number which has already been surrendered by the petitioner. Full stop. He submits that an appeal cannot be allowed to be presented on a surrendered permanent account number. Mr. Singhania, this is your submission. Full stop. Since legal as well as since legal and factual issues have been raised in this writ petition, this court feels that the writ petition is to be decided after exchange of affidavits. Stop. Let affidavit in opposition be filed within 3 weeks from why 6 weeks? So only a legal issue, why 6 weeks? 3 weeks from date, semicolon, reply thereto, comma, if any, comma, be filed within a week thereafter. Full stop. Parties will be at liberty to mention this matter for hearing after the expiry of the period fixed for exchange of affidavits.
Let's say item number 24 is same, Your Honor.
24 is same, assessment here is.
Assessment here already.
I have not mentioned the assessment here.
Yes.
So same order.
24 same order.
Same order.
But
Separate
the
order, same
dates
order.
will be changed. Dates will change.
Oh, dates.
Yes.
All right, 24 file to din to 24 টা এতে দেখিয়ে দিন বোর্ডে।
24 আছে। Page number 19, my lords, will find my prayer where I have specified.
But in the earlier matter,
Yes,
where have you mentioned the assessment here? You have not mentioned the prayer, the assessment here.
Not taken in the prayer, but it was there in the body.
All right. Acha, next matter টা না item number 24 এ ওই assessment order dated March 9, 2023.
Yes.
Semicolon, the penalty orders dated September 14, 2023 and September 18, 2023.
Yes.
Others are same.
Others are
Same.
same. Others are same.
Same order.
I'm grateful.
Yes, next.
My lords, I appear for the petitioner. I appear for the petitioner. Item number 15.
15.
Yes.
And for the respondent, my lord.
Yes.
There's an unusual case, my lords. This is relating to VAT assessment. I am challenging the assessment order. The assessment order is of the year 2009-10, and they have served me the assessment order in 2025. And my lords, what happened was there is a previous history also. For the financial year 8-9, they had served me an assessment order in the year 2022. I filed a writ petition before this honorable court. The writ was finally, it was passed in my favor. When I went to the department to communicate that order and asking them for a refund, there they supplied me with this orders of 9-10. So I will first take you to the order which was passed in the first round, my lords. Page number 20 to 27.
What is the order which you are challenging?
Order is from page 28 to 30.
This is for the assessment year 2009-10.
Yes, financial year 9-10. This is a notice of
No,
demand.
assessment period 9-10.
Yes.
1st of April 2009 to 16th of April
Yes, for
2009.
16 days.
Yes, this is
Yes.
the assessment period.
Yes. Next page is the assessment order, page number 29. And page number 30 also, they give me this letter. Then I file a representation at page number 31.
Yes.
This was not considered till now. And what is important, my lords, is the first round where I got the order, my lords. Kindly take that, page 20 to 27.
Yes. Yes. So this was set aside.
Yes. Now, my lords, again they have
Non-compliance to establish mandatory
Actually,
requirement of Rule
Form
56.
25.
Rule 56.
Rule 56.
Rule
Minus
56
two-
is Form 3025.
Yes,
Yes,
25. That they have to show that they have served me.
Minus, that's why a report is required to be called
Yes.
for.
Let them file an affidavit, my lords, but till then, no recovery should take
No, my
place, my
lord.
lords.
What recovery?
This is a 13-year-old demand, my lords.
There is no requirement of any stay, my lord. A report may be called for.
My lord,
Whether,
Why?
yes,
my
my
lord,
lords.
my
You
lord,
have
yeah,
issued a demand notice. You have issued a demand notice.
And after 13 years, my lords.
You have issued a reminder of assessed dues.
Yes.
So
They have
this is of
already filed-
2013.
Yes.
This is of 2013.
And they are giving me in 25, my lords.
2025. When have you served?
my lord, for that reason, my lord, a report is required to be called for. That
Affidavit
whether
is-
any
So you
service
cannot
is done. or-
realize this amount now.
Yes.
We will not, my lord. Anyhow, they will not, because the writ has been filed, they will not, my lord. Because in earlier case also, there was no stay
No, no.
order, my lord, and no recovery was
No,
done,
no,
my
my
lord.
lords, in the earlier case, amount was already recovered. And I was granted a refund by this court.
Writ is filed, my lord, they will, anyhow, they will not recover any amount, my lord.
This was for which period? The
The
earlier
pre-
one?
Earlier one was for 8-9 financial year.
And this is for 9-10.
9-10.
And
You
during,
not get anything. It's the same office.
yes, my lord. And
I-
three,
The
my lord,
same office.
yes,
I cannot take that burden, my lord. Let them file a report,
yes,
my lord.
I don't have.
No,
a
no,
problem.
that is
Fine.
the different
Fine.
thing altogether. But if the earlier report says that you do not have
They
any
have any
papers,
papers, my lord.
I should be protected, my lords. That is my.
That order was an appealable order. Assessment
Yes,
order was an
yes,
appellable.
Yes, yes,
Yes.
Uh, The petitioner has challenged the ex parte assessment order dated June 18, 2012 for the period 1st April 2009 to 16th of April 2009, passed under the provisions of the Value Added Tax Act. Under which section this assessment was made? Where do I find that?
West Bengal Value Added Tax Act 2003.
They have not even struck off the.
West Bengal
applicable.
Value Added Tax Act 2003. And the notice of reminder of assessed dues dated 1st of February 2013. Where is form number 27?
Form number 27 is at page 28.
And the form number 27. Full stop. The petitioner alleges that the assessment order, comma, the reminder letter dated 1st of February 2013 and the notice of demand under form 27 were all served upon the petitioner on or about September 12, 2025, when the petitioner went to serve the copy of the, that is your case,
Yes,
went
yes,
to
yes.
serve the copy, which paragraph?
My lords, in my representation, I have stated page number 31.
Not in the writ petition.
In the writ petition also I have stated.
Which paragraph?
My lords, page para 5, page 3.
When he went to serve a copy of the order dated
Para 8 also.
August 19, 2025,
September.
passed in WPA 359 of 2023. Mr. Lakotia, learned advocate appearing for the petitioner, submits that no notice in form 25 nor the assessment order was ever served upon the petitioner. Full stop. It submits that Rule 56 of the West Bengal Value Added Tax Rules, 2005, casts an obligation upon the concerned authority to serve a notice in form number 25 on a dealer, directing him to appear in person or through his authorized agent upon to serve a notice in form 25 on a dealer, directing him to appear in person or through his authorized agent on the date and at the time specified therein for compliance with the requirement of section 56 within bracket 5 for the purpose of assessment of tax in respect of a particular period. He submits that there has been non-compliance on the part of the respondent authorities of the mandatory requirement of Rule 56 of the 2005 rules. Full stop. The learned advocate appearing for the state prays for an accommodation to take complete instructions in this matter. Full stop. Though the order, though the assessment order is an appellable order, but in view of the specific stand taken by the petitioner that the assessment order in question relates to a period from 1st of April 2009 to 16th of April 2009, was never served upon the petitioner at the relevant point of time, and the same was served after a lapse of more than 15 years.
13 years.
After a lapse of 13 years from the date of passing the assessment order, this court is inclined to entertain this writ petition on the peculiar facts of the instant case. First up, the writ petition is admitted. First up, let a report in the form of an affidavit be filed by which respondent?
Respondent number 1.
Respondent number 1.
By the first respondent within a period of
2 weeks, my lord.
2 weeks from date. Full stop. List this matter immediately after expiry of the time fixed for exchange of.
My lord, let not recover.
List this matter for filing of the report in the form of an affidavit.
My lord, some recovery proceedings.
No, that recovery proceeding notice.
Record reveals that a reminder of assess that a notice dated 1st February 2013 or 1st December 2013? No, 1st February 2013.
There is no recovery proceeding initiated, my lord.
On the subject reminder of assessed dues for the period 2009-10 is claimed to have been submitted upon the is claimed to have been served upon the petitioner sometimes in the month of September 2025. This court is inclined to pass an interim order. There shall be an order restraining the respondent authorities from taking and from realizing.
But they have not annexed that document.
Yes.
No,
Page,
my
page 30.
That's of 2013, my lord. 2013.
Yes.
My lord.
That notice he says we have served in 2000.
2025.
কি বললাম? The respondent authorities from taking any coercive steps and from realizing any amount from the petitioner pursuant to the assessment order dated 18/6/2012.
Yes.
Dated 18/6/2012 for the assessment period 1/4/2009 to 16/4/2009 until further orders.
I'm deeply grateful.
I'm grateful, my lord.
For the petitioner, item number 16, Lordship. This is my affidavit of service.
Yes.
Lordship, in this matter, I beg for time, Lordship, for often instruction, Lordship.
Yes, what is this matter?
Lordship, I was appointed as additional volunteer teacher in a state aided school, Lordship. Subsequently, I have given the status of para teacher, Lordship. Now, on 30/7/2022, one FIR was lodged against me under section 10 and 21 of the POCSO Act, Lordship. I got bail and I prayed before the concerned authority to reinstate me in my post. They denied, my lord. Subsequently, the learned trial court gave acquittal to me, Lordship. After 8 months,
You are honorably acquitted.
Lordship, yes.
Show me the order.
Kindly come to page number 29, my lord. I'm reading the operative portion, Lordship. That the accused, namely Vikas Singh, is held not guilty for the offence punishable
All
under
right.
section-
Yes, yes.
I have given acquittal, my lord. After 8 months of my acquittal, the concerned authority has reinstated me in my post, Lordship. Now, my lord, during the entire period of trial, my lord, I was not given any suspension letter, but I was not allowed to work on my post, my lord. Now, the learned trial court has clearly mentioned I was not guilty, my lord. So I'm praying for my back wages, my lord. And at this juncture, my lord,
Any
I'm
decision taken on your claim?
on
For
my
back-
claim, my lord, no.
Where is your application for payment of back wages?
My lord, it's at page number 34, the last page. I prayed through my TIC. There's a teacher in charge to the district education officer. And my lord, at this juncture, I'm placing reliance on judgments of honorable, 2 judgments of honorable apex court, my lord.
Yes.
2013 10 SCC 324. My lord, kindly come to paragraph number 22, my lord. At the bottom, my lord, I am reading it out. The denial of back wages to an employee who has suffered due to an illegal act of the employer would amount to indirectly punishing the employee concerned and rewarding the employer.
No, this is not an illegal act of the employer.
Not by employer.
So this judgment may not apply to your case.
Lordship, I come back
So
to this question, Lordship.
if it is on the illegal act of an employer, so complaint was made under the a criminal complaint was made.
Lordship.
So it's employer had nothing to
But
do.
my lord, after
no
getting
role on that.
Yeah, on that part, my lord, I agree. But my lord, there is something other thing is there, my lord. After getting bail, my lord, I prayed before them to allow me to join. That also struck down, my lord. They didn't allow me. And
But
after
you did not challenge at that relevant point of time.
at that time, because there was litigation, several allegation was pending against
All
me, my
right,
lord.
so yes, you take a decision on this
Another
representation.
judgment was there, my lord. So
Judgment's very difficult. By
I'm
whom-
trying.
There are many things against you in this. So
I'm trying to take.
I'm aware of this judgment. That is why I'm not
They
entering
never
the
paid for any reinstate, Lordship.
Lordship, I am showing it to you. Kindly come to.
salary areas they have claimed. No, he has been reinstated. Now
I'm claiming for back wages.
Yes, back wages. He has
Back
been
wages.
Lordship, I
reinstated.
come back to the instruction, Lordship.
Consider this. The petitioner claims to be the petitioner was engaged as a para teacher and serving. The petitioner claims to be a para teacher serving at Mateli Rashtrabhasha Vidyalaya High School.
Yes, Lordship. Meteli Rashtrabhasha Vidyalaya High School.
Yes, full stop. On the basis of a complaint lodged, on the basis of a criminal complaint lodged against the petitioner, a criminal case was initiated and the petitioner was initially taken to custody and subsequently released on bail. The petitioner was acquitted by the additional sessions judge, Mal District Jalpaiguri, by a judgment dated September 27, 2024. After being acquitted in the criminal case, petitioner applied before the concerned authority for reinstating the petitioner. First up, petitioner alleges that there was some delay on the
8
part
months delay.
that there was about 8 months delay on the part of the authorities in reinstating the petitioner as a para teacher of the said school. First up, petitioner claims to have submitted a representation praying for release of the area salary.
And back wages too, my lord.
And where have you said back wages? Area salary you have said.
Lord, petitioner is not, he is a layman, my lord, so he didn't use that term back wages, my lord. But in this writ, my lord.
Then I will give you a liberty to file a comprehensive representation to that. Otherwise, it will be a difficult thing. Because here it has been only stated area.
Area salary, yes, my lord.
So I
That's
give you liberty, you submit a detailed representation that will be considered.
for back wages, my lord.
Detailed representation mention everything what you want.
Lordship.
কি বললো? Area salary, full stop, paragraph. The learned advocate appearing for the petitioner submits that the petitioner is entitled to area salary for the period from the date of acquittal by the criminal court as well as back wages. Lordship. Full stop. The learned advocate appearing for the petitioner, in his usual fairness, submits that since the petitioner is a layman, he or she, a POXO, he could not was a layman, he has not specified all his entitlements in the said representation. Full stop. The learned advocate appearing for the state and heard the learned advocate for the state. Full stop. He submits that the petitioner is not entitled to any back wages or area salary. Full stop. Paragraph. After going through the representation, this court finds that the same is not a comprehensive one. Full stop. In view thereof, this court is inclined to grant an opportunity to the petitioner to file a comprehensive representation ventilating all his grievances before the concerned authority. Who is the appropriate authority? District
Education Officer.
Full stop. As WPA number such and such stands disposed of by giving liberty to the petitioner to file a comprehensive representation, to submit a comprehensive representation before the District Education Officer, SSM Jalpaiguri, being the, which respondent? Being the second respondent, along with a server copy of this order. Full stop. If such a representation is submitted, the second respondent shall consider the same and dispose of, shall consider and dispose of the same by passing a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative and communicate such order to the petitioner immediately thereafter.
And within 7 days kindly mention,
The
otherwise.
entire exercise shall be completed within a period of how much time?
Lordship, 4 weeks, Lordship.
4 weeks from the date of receipt of the copy of the representation as directed to be filed pursuant to this order. Disposed of. যদি না বলা থাকে disposed of. Yes, next.
Item number 70. That's in item number 7.
Take back this judgment.
Yes, Lordship.
আচ্ছা ওটা একটা লাইন যোগ করে দিন. It will be open to the petitioner to rely upon any circulars, notifications or any orders passed by any court of law in support of his contention for claim, in support of his claim for back wages, area salary, etc. Yes, yes. Who is appearing?
Lordship, item number 17, council at online, your lordships.
Yes.
Your Lordship, I'm appearing on behalf of the petitioner. I am being led by Senior Advocate Mr. Aniruddha Chatterjee and my senior Shomore Chaudhary. Your Lordship, we couldn't communicate. The communication of this particular writ petition was not was not served on. Was not delivered to all the other sides. I think it's only delivered to probably one of them. So I was requesting for keeping it on the next.
What is the order under challenge?
Your Lordship, it's not the order under challenge. It is basically we are challenging the inherent lack of jurisdiction on the part of the State Consumer Dispute Resolution Commission for entertaining a particular consumer complaint which is undervalued. So, in that regard, Your Lordship, we have filed this particular writ petition. The respondent number, Your Lordship, if Your Lordship sees the respondent number 2 and 3, they have filed a consumer complaint which would be evident at from page number 138. They have filed a consumer complaint regarding indeficiency of service on the part of performer number 4, who has been given the right to take care of that particular property. Now, Your Lordship,
an application under Article 226 because the Consumer Forum is a tribunal.
Yes,
it
Your
has been held
Lordship.
by the Honorable Supreme Court. It's a tribunal. So, is Article 226 or 227 maintainable against any inaction or
Your Lordship, 226.
superintendence, power of superintendence? So, whether 226 or 227 would be the appropriate application, madam?
Your Lordship, 226 is applicable because, Your Lordship, the judgment says that writ court has the power to interfere when there is an inherent lack of jurisdiction to be decided, and even if there is an alternative
I'm
remedy.
asking, madam, either 226 or 227, because Consumer Forum is a tribunal which has been held by the Honorable Supreme Court in the very recent decision.
Indeed, what I would request, Your Lordship, I have
So,
been
whether
given
226 or 227.
Your Lordship, when it's come to superintending jurisdiction, it is obviously 227, but we have exercised this particular jurisdiction of Your Lordship is because of the fact that there is inherent lack of jurisdiction and writ court has the power to interfere. When there is inherent lack of jurisdiction
Have you
on the part
considered
of...
those line of decisions where 226 or 227 will be applicable? There are a line of decisions on this.
Indeed, all I'm requesting, Your Lordship, let my seniors
there are
join and explain.
decisions which says in which cases 226 and in which cases 227.
Your Lordship, I completely agree with Your Lordship's recommendations, but let my senior come and maybe apprise Your Lordship on this point.
Where is
If
your
it's-
senior?
Your Lordship, he's stuck in courtroom number 16 probably. So if Your Lordship can make it a passover or maybe give a direction for completion of the service of the writ petition.
The learned advocate appearing for the petitioner submits that, yes, Mr. Singhania, what is your submission?
Service not completed, Your Lordships, and the senior councils are engaged in this case. Can I take the next submission?
What is your submission, whether 226 or 227, which is maintainable?
Lordships.
You have not considered this issue.
Your Lordship, we have honestly considered it, but I'll give you one picture, Your Lordship. We have taken this particular point of inherent lack of jurisdiction before the State Commission. State Commission didn't agree to it. We have also taken it before the National Commission. National Commission didn't look into it, Your Lordship. So today, our only way of addressing was, Your Lordship, this writ jurisdiction. But I won't speak on this much because we have judgments to satisfy, Your Lordship.
In that decision, in a decision the Honorable Supreme Court has held whether 226 or 227.
Again, Your Lordship, I am just a carrier of instruction.
Your
Let's just.
Praise for an accommodation as the service of this writ petition has not been effected upon the respondents. First up, the issue of maintainability of the writ petition is kept open. First up, petitioner is direct list this matter before the since the orders passed by the
State consumer.
since it's the district forum of the state commission initial one.
State, Your Lordship, State Commission.
Since the orders passed by the state commission and the national commission pursuant to a consumer complaint filed before the state commission is the subject matter of challenge in this writ petition. The issue of maintainability of the application under Article 226 is kept open.
May I request Your Lordship, before service, this is like giving ideas to the other side to make submissions. What if they are not equipped enough to do that? My only request is kindly don't record it, Your Lordship.
Maintainability is the court's discretion whether to you have moved even
Kindly, Your
on the
Lordship.
other side. I can take up this point.
Indeed, Your Lordship, but my
That,
request
yes,
is before service.
This has to remain. Maintainability you can satisfy whether 226 or 227. There are a line of decisions on this, madam. List this matter before the next available circuit bench. Yes, Mr. Singhania, please go through those line of decisions. There are line of decisions on this.
Grateful, Your
Yes.
Lordship.
Lordship, I'm for the petitioner, Lordship. The service is not complete. We are challenging the termination agreement between the PPCL.
Termination.
Yes, Lordship. This case was heard by your Lordship on 28/10/2025.
28th
10/2020.
was hard.
Yes, Lordship. We were supposed to file supplementary affidavit.
Under writ petition,
Yes.
that was taken up by my lordship.
Oh.
Therein the termination was not under challenge.
Yes.
During the pendency, the termination has come up, so now the termination.
Petitioner is directed to serve a copy of this writ petition upon the respondents and file an affidavit of service on the next date. List this matter before the next available circuit. Yes, next.
Maintainability is my
Yes.
This
Yes.
petition is a challenge that transfer order of a bank authority, my lordship.
Where is the order of
Yes,
transfer?
order is my lord, page 24, my lord. The bank authority issue a transfer order without violation. Page 24, my lord.
What is your name? Chandan Kumar Jha.
Yeah, yes. Without taking the provision and guideline of the transfer policy, my lord. Only, my lord, that Chandan Kumar Jha, senior bank manager, is hereby transferred to Canada Bank, Region 1. What's happened, my lord? Before 5 months back, 5 months back, my lord, she transferred from Bongaigaon to Siliguri. And during 5 months, again she transferred, my lord. Whereas, my lord, transfer policy provides for a minimum tenure of 1 year, maximum 3 years. My lord, kindly see, my lord.
It's merely a guideline.
Yes, guideline.
Whether these guidelines has any statutory force.
Yes, my lord,
Statutory force.
Yes, my lord.
Show me a judgment.
No, my lord,
Judgments are
my lord,
otherwise.
these transfer.
Judgments are otherwise, I am telling you. These guidelines do not have any statutory force. These are mere guidelines. So,
Guidelines follow, my lord.
yes, in case there is any violation of these guidelines, mandamus will not lie. Please show me a decision.
No, my lord, kindly
Mandamus
see
will
page
lie
15,
for.
my lord, page 15, kindly see page 15.
Yes.
Page 14, my lord, first page 14, my lord.
Yes.
Tenure of years, my lord, minimum and maximum. The 1 year and 3 years.
Yes, I accept your submission in the guidelines. I'm
And
asking
page
you.
15, my lord.
whether these guidelines have any statutory force. Show me under what statute, under what power these guidelines have been framed.
These guidelines is guided by the Reserve Bank of India. Kindly see page 15.
Show me under what
Kindly page
rules it has been framed.
15 minutes, kindly.
Transfer policy,
Yes.
nothing.
There is a appeal provision, my lord,
For
grievance of the grievance transfer. My lord, kindly see page.
prefer an appeal?
My lord, I have prepared an appeal. My lord, till now, my lord, no decision was taken, my lord. My lord, kindly
Till now, no decision has been taken.
yes, my lord, kindly see, my lord.
So I'm directing the
My
appellate
22,
authority
page
to
22. My lord, kindly see page 22.
24 years. Have you served upon the bank?
22, my lord. Yes, my lord, I have served. Urgent is that, my lord.
Proceedings,
Page 22, my lord.
page 22.
Yes. Transfer grievance and redressal.
Yes. Now,
And transfer appeal, my lord.
transfer appeal. So initially you approach the transfer grievance
Yes.
redressal
Yes.
forum.
Yes.
Then transfer appeal.
Yes.
So where is the initial order? By the grievance cell.
Page 25, my lord. This is my
Representation before the
Yes.
grievance cell.
grievance cell.
Now what is the order passed by the grievance cell?
Well, till now, my lord, nothing has been passed, my lord.
So
And
grievance
page-
cell has not passed any order.
Yes, my lord.
Now you have said appellate authority has not passed any order.
Grievance cell and as well as appeal authority, both, my lord, I have.
How can you approach both at the same time?
Page 20. Oh, no, my lord. Sorry, my lord. Page 27, grievance cell has communicated.
Page 27,
Yes.
grievance cell has communicated. Where is the
27 page. Thereafter, my lord, page 28.
for your benefit, sir?
No, my lord, kindly consider one thing.
Not completed the required rural semi-urban service to be eligible for promotion.
My lord,
to
I am not
SMG.
taking any promotion. I am not
is-
not request
that
any
is-
transfer, my lord. Within 5 months, I have twice transfer, my lord. But initially, my lord, kindly
All right, then against that you have
Yes,
submitted a
20
representation before the appellate authority.
Yes, the Chief General Manager of Bangalore, my lord.
That is 4th of November 2025.
Yes,
No decision on that.
yes. And there is a only limited period for joining, my lord.
I am directing that appellate authority to dispose of that.
No, in the meantime, my lord, no. Otherwise, my lord,
It's a transferable
Milord,
job. You
my
have
lord, kindly
to
see page
join.
11 for a moment. Page 11, my lord, page 11.
Yes, yes. Please join.
Page
And
11.
appeal is pending. I am directing the appeal to be disposed of. If you succeed in the appeal, you will again
My
be
lord, page
rewarded
11,
back.
my lord. Kindly see page 11. Page 11. my lord.
Yes,
Annex
page
seven.
11, yes. Yes,
My lord, on my lord, May 2nd May.
yes.
2nd May, I was transferred from Bongaigaon to Siliguri. Within 5 months, they issue another transfer letter.
What is the date within which you have to join?
My lord, there is no date, but there only she is eligible to 7 days for joining time, including journey fuel. And my
So
lord,
that is already over.
my lord, now I am in medical leave for my family. And my lord, what's happened, my lord?
Since
And that
till which time you are on medical leave?
my lord, I
Till
have made
which
a
time you will be
representation.
on medical leave?
I made a representation before the authority on medical leave. Now I am in medical leave for myself and as family.
So I'm directing this. I'm not
And my lord,
saying anything with regard to
the place.
I'm not saying
the place
anything.
is beyond body. My lord, it is a very remote place and hilly
That
area.
is a difficult.
Within 5 months, it is not permissible the transfer policy, my lord. And also there is also, my lord, in the transfer
You
policy
have
there is
prepared
an
an
option.
appeal. I can direct the appellate authority. That's one way. If you want to move on merits, I can also consider. I can
My lord,
direct filing
yes,
of
my lord,
affidavits.
the direction was given to the appellate authority to consider. In the meantime, my lord, no point.
Not in the meantime.
No.
I'm keeping that. I'm not making any observations on that.
Well,
I
otherwise,
think
my lord,
it's
I will-
better. You go on doing whatever you are doing. Otherwise, some other proceedings will come up. The petitioner alleges that he has been frequently transferred from one place to another by the authorities of Canara Bank in violation of the guidelines, in violation of the transfer policy.
Of the
So the petitioner claims to have submitted a representation before the, where is that grievance redressal? Where is that rules? Which page?
Page, my lord,
Submitted a
24.
representation before the transfer grievance cell, and the prayer of the petitioner was rejected by the grievance cell, and the petitioner thereafter preferred a transfer appeal before the concerned authority. Which is the authority? Have you implemented the committee, transfer committee, appeal committee?
No, my lord.
Full stop. Where is your representation?
Page 30, my lord.
30. The learned advocate appearing for the petitioner submits that the petitioner submitted a representation before the concerned committee dealing with the transfer appeal matters by a letter dated by an email. Email dated
4th November 2020.
4th November 2025. Only 4th of November. Full stop. The learned advocate submits that a direction be passed upon the concerned authority to dispose of the appeal expeditiously. Full stop. Affidavit service filed in court today is taken on record. The learned advocate appearing for the petitioner submits that the respondent bank has been duly served.
No, not 4th November. My lord, transfer appeal 30th October 2025.
30th October 20, 4th November now.
4th November,
30th of October 2025. The learned advocate appearing for the petition submits that the respondent authorities have been duly served. So, however, none appears to oppose the prayer of the petitioner. First up, paragraph. In the light of the submissions made, since the petitioner has approached the concerned authority dealing with the transfer appeal, this court is of the considered view that the interest of justice would be subserved if such authority is directed to dispose of the appeal expeditiously. First up, in the light of the submissions made by the, in view thereof, WPN number such and such stands disposed of by directing the concerned authority of the Canara Bank dealing with the transfer appeal to dispose of the representation of the petitioner dated October 30. October 30. October 30, 2025. Dated October 30, 2025. In accordance with law as expeditiously as possible, but preferably within a period, but positively within a period of 3 weeks from the date of communication of from the date of receipt of a server copy of this order, along with the appeal petition filed before the concerned authority.
2 weeks. 2 weeks.
Don't bargain with the court. Yes, next.
Item number 20. My lord, I am for the petitioner. This is my affidavit of service.
Lordship, I am appearing for the respondent number 4, CGST, Lordship. Answering
Yes.
respondent is state.
My lord, I received one show cause notice from the Joint Commissioner State Tax Siliguri. Malad, kindly come to my show cause notice at specific pages at page number 22.4F.
Page number 22.
Yes, my lord.
Yes.
In this show cause notice, my lord, one of the reason for this show cause is that ITC availed in GSTR 3B filed after last date prescribed under section 16.4, and they have mentioned the last date as 20th September 2020.
20th October.
October, sorry, my lord. My lord, I filed my GSTR 3B on 25th on 25th November on the said year, my lord. Now, my lord, the CGST authority has issued a notification, my lord. They showed.
No, you have replied to the show cause notice.
No, I'm coming to that. Yes, I replied, my lord. I am coming to that.
Then what happened after that?
They passed an order against me.
You are heard.
I was heard, my lord.
Yes.
Subsequently, my lord, an adverse order has come against me.
Yes.
I filed an application under section 148 of the CGST Act. And that too within the time limit, my lord.
148 for what? For
For,
rectification.
For rectification, my lord.
Yes.
Now,
Well,
by
Lordship, may I
keeping
interrupt
this,
once?
Yes.
Lordship, this is the answering response to the state Lordship.
State.
my lord.
Yes, yes.
State is party, my lord. Extreme urgency is there, my lord. I have served
Oh,
the
their
state too.
AGP is here,
Yes.
Lordship.
Where is the state?
Yes, our learned AGP is there.
With extreme urgency.
All revenue matters with soccer you have been assigned, and you are saying you have not been assigned. You have served a copy.
Yes, my lord. Affidavit of service has already been.
When have you served? Upon the GP, you have served.
Yes, yesterday, my lord.
Yes, sir.
My lord, I filed this matter with the leave of this court, my lord, with extreme urgency.
They have to take
And
instructions.
my lord, one more thing, my lord. By keeping my application pending, they issued a notice to the bank account where I to my bank where my account is there, my lord, and they are trying to take 2 crore rupees from my account, my lord. This is my entire business capital, my lord, and opportunity of hearing has not been given to me, my lord.
Where is that notice?
At page number 46 P9, my lord. They issued to the branch manager PNB. And they are claiming that rupees 2 crore 16 lakh to be given to them, my lord, by keeping my application pending. And my entire business capital is involved therein, my lord.
All right, Ms. Sokka, please go through this. I am passing it over. After the last matter, I will take up. Please go through.
Obliged, my lord.
Yes. Yes, call the next matter. Yes.
Yes. In item number 21, my lord, I am for the petitioner. My lord, this is my lord, the petition against the rejection order of my transfer application. Rejection order of my transfer.
What do you want?
My lord, I want my lord transfer my lord, from Jalpaiguri to my lord, the Birbhum district. And my lord, I applied. My lord,
yes, who is appearing for this? Which is the authority we will consider?
My lord, they have considered my application. Well, they have considered my application, and the prayer my prayer has been rejected. Well, the West Bengal, well, the Secretary, West Bengal Board of Primary Education.
Where is that? Where? Which page?
Well, at the page 61, 62. Page 61, 62, my lord, of my application, madam. This is the rejection order.
Yes, what is your submission?
The submission is that, my lord, they have reacted my application, my lord, on the ground of the, my lord, the deficit of the teacher. My lord, that observation, my lord, is not correct. Because, my lord, I am the surplus teacher, my lord, in the school, my lord, where I am now serving, my lord. My lord, there, my lord, can you see the page? My lord, the page 20, para 23, page 13.
Para 23 page.
Para 23, page 13.
Yes.
Yes, my lord, in para 23, my lord, page 13, my lord, there are, my lord, 6 teachers. My lord, my lord, 4 assistant teachers, 1 para teachers, and my lord, 1 teacher in charge. Total 4 teachers. And my lord, can you see the, my lord, the people, student, my lord, the people, my lord, the, and my lord, the student, my lord, the teacher, my lord, ratio, my lord, can you see, my lord, the, my lord, page 62. Page 62.
Page
62.
Yes, yes.
My lord, the serial number, my lord, the 4. My lord, the between 121 to 200. My lord, I am, my lord, there is, my lord, 133 students. My lord, 5 teachers. My lord, where, my lord, in the state school, my lord, where I am serving, my lord, there are the 6 teachers, including me.
No, this number of teachers, whether it will include para teachers or not, that's the
My lord,
issue.
para teachers also, my lord, the para teachers also the teacher. Also the teacher, my lord, he is
No,
paid by the government. He is paid by the government.
Whether
Even,
while calculating this ratio, whether the para teachers will be included, please show me those
my lord, according
provisions.
to, my lord, the para teacher, my lord, is given, my lord, the status of the
Alright,
teacher, my lord.
so let them file their affidavits.
No,
Let
my
them
lord,
file
the
their,
kind is,
you are challenging a rescinded order. Sir, they have to be given a chance.
no, my lord, can you see the supplementary affidavit, my lord? Also, my lord, I have filed the annexure P8, my lord. My lord, annexure 8, my lord. Annexure 8, my lord, this, my lord, annexure 8, my lord, the 3rd page of the annexure 8 is missing, my lord. That is why, my lord, I have affirmed the supplementary affidavit, my lord. My junior is there, my lord, Mr. Jogesh Roy, my lord. I request him, my lord, to hand over the supplementary affidavit to your lordship, my lord.
Yes, yes.
But in the supplementary affidavit, my lord, can you see this is the, my lord, transfer order of the one Asma Khatun. One Asma Khatun. My lord, page 6 and 7. Yes, my lord, that's page 7. My lord, she has been transferred, my lord, from her school, my lord, to another school, my lord. Can you see?
Yes.
In the set para 8. Para 8. The present school of the petitioner is running the student 310. And 6 teachers, including the petitioner. So the petitioner is a surplus teacher. And my lord, can you see the ratio of the, my lord, teacher, my lord, can you see? My lord, my lord, the ratio, my lord, can you see above, my lord, above 200, people teacher ratio, including the headmaster, shall not exceed 40. So, my lord, every 40 student, 1 teacher. So, my lord, according to 310, there should be the 8 teachers. But, my lord, in spite of having the 6 teachers, they observed, my lord, she is the circular teacher, and she has been transferred to her, my lord, according to her choice. Now, my lord, though, my lord, I am the surplus teacher, the 6 teachers, my lord, if my lord, the para teacher is not the teacher for argument's sake, then there are the 5 teachers.
No, excluding the para teacher, there are 4 teachers only.
5 teachers, my lord. Can you see? I have stated 4, my lord, the 4 teachers, 1 para teacher, 1 teacher in charge. Can you see paragraph 23? Paragraph, my lord, 23, page 13. Page 13. My lord, 4 assistant teachers, 1 para teacher, and 1 teacher in charge. And
Yes, Mr. Shah, what do you say? Have you served a copy of the supplementary affidavit upon them?
Yes, yes.
Just now. So let them consider this. You have served this supplementary affidavit just now. Let them file an affidavit with regard to this, because you are trying to make out a case of discrimination. One person has been transferred, you have not been. So they have to deal with these allegations.
One of the very short time, because one of the lady in Siliguri, Jalpaiguri,
All right.
400 kilometers away from her resident, and there is the one application, the district
So
board.
then why did you accept this job? At the time of appointment, why did you accept this job?
My lord, the question of livelihood, my lord.
Yes.
Question of
So
livelihood.
at that point of time, distance was not a factor.
Question of
sir.
livelihood, my lord. Question
So
of livelihood.
when you applied, you ought not to have accepted that. Someone could have
question of livelihood.
joined. Yes. So don't take that plea of distance, long distance. Don't take that plea at the time of taking appointment. That was not. That did not trouble you. Now, once you get an appointment, that troubles you. The long distance. This should have come to your mind at the time of taking the appointment, not after that.
My lord, so far the supplementary affidavit concerned, my lord, transfer has been granted
Yes,
on the
yes.
ground of the
So-
district.
so-
However, my lord, but there is one application where the district primary council has not been made party.
That is,
my lord, I have
that
made
is, a,
party,
that
my
is
lord,
a
that there is
different thing
application, my lord.
altogether. You are taking these points, distance factor and other things. I'm keeping my mouth shut. I have not made any observations. But since you have made this shorter
But
time,
very
that is why
short time, my
long
lord, kindly.
distance.
But a very short time, my lord, kindly.
They have
Very
to be
short
given
time.
Sir, you have served a supplementary affidavit just
But-
today.
Yes, yes,
Case
yes.
of discrimination. This has to be considered.
Yes.
And
Let them file the affidavit, my lord, but within
and
short
even
time.
if the wrong order was passed in some cases, negative equality, you cannot get the benefit of that. So they have to deal with this.
Yes.
Uh,
Well, let them file the affidavit, my lord, but
yes.
within very short time.
The order rejecting.
My lord, the one thing, my lord, the application, my lord, that is can number 1, implementing the, my lord, the district primary council and the chairman party, my lord, kindly, my lord.
All right. So can I'm allowing. Where is that
Yes.
can?
There's the can number 1.
Can 1 of 2025. This is an application for addition of the which paragraph?
Paragraph.
Application
My lord,
for
the paragraph 1 and
including
2.
the District Primary School Council Jalpaiguri
And its chairman. Yeah.
as party respondents in this writ petition. First up, after going through the scope of the writ petition, this court finds that the primary school, the District Primary School Council and its chairman are necessary parties for the purpose of effective adjudication of the disputes involved in this writ petition. First up, in view thereof, can 1 of 2025 stands allowed. The district the District Primary School Council Jalpaiguri and the chairman of the said council are impleaded as party respondents in this writ petition. First up, the learned advocate on record of the petitioner is directed to amend the cause title of this writ petition. Full stop, petitioner is direct, না তারপরে লিখুন, the learned advocate appearing for the, আচ্ছা can ওইটা allow করে দিন, ঠিক আছে, can ওইটা allow করে দিন, can 1 stands allowed, full stop, তারপরে লিখুন ওই writ petition এ করুন, the learned advocate appearing for the petitioner prays for leave to file a supplementary affidavit. First of such leave is granted. The supplementary affidavit filed in court today is taken on record. A copy of such supplementary affidavit has been served upon the learned advocate representing the state in course of hearing of this writ petition. First up, paragraph, the petitioner has challenged the order passed by the Secretary, West Bengal Board of Primary Education, rejecting the prayer of the petitioner for transfer from the school where she is present, he or she is presently serving to school near to the residence of the petitioner.
At Birhum.
The learned advocate appearing for the petitioner submits that in the supplementary affidavit, the petitioner has demonstrated, the petitioner has specifically stated that the petitioner has annexed the copies of the recent order passed in the case of another assistant teacher and
Asma Khatun.
submits that the petitioner has been discriminated against while considering the prayer for transfer. First stop, petitioner is directed to serve a copy of this writ petition along with the supplementary affidavit upon the added respondents serve a copy of the amended writ petition. Serve a copy of the amended writ petition and the supplementary affidavit upon the added respondents and file an affidavit of service on the next date. First up, the learned advocate on record of the petition shall be obliged to serve a copy of the amended cost title of the writ petition upon the learned advocate for the state and the Board of Primary Education forthwith. First up, let affidavit in opposition to the writ petition and the supplementary affidavit be filed. Yes, Mr. Shah, how much time?
4 weeks.
Why 4 weeks? Within a period of 3 weeks from date, semicolon reply thereto, comma, if any, comma, be filed within
1 week.
Within a
1
week
week.
thereafter, parties will be at liberty to mention this matter under the heading for enlistment under the heading hearing after the expiry of the period fixed for exchange of affidavits. Call the next matter.
My lord, I am on online, my lord, Mohammed. My lord, I am on online, Mohammed Ashraf Ali, my lord, let my name be recorded, my lord.
Yes, yes.
My lord, in this
Keep
matter,
the names. Yes.
my lord, in
Mr.
this
Roy,
matter, I have
Yogesh
been
Roy,
led by
please give
Mr.
my name.
Verma, appearing virtual.
Yes,
My
put
lord,
the names. Yes.
my
Yes,
lord, I
yes.
am appearing
I'm
for the
for
petition.
CGST.
Mr. Verma is appearing virtually.
I'm appearing virtually, my lords.
Yes, yes.
My lord, this is yesterday. This matter was being called. My lord, my learned friend has to seek instruction for that.
Yes.
My lord,
Yesterday, I was not in a position to appear due to some difficulty.
Yes, yes.
Dear
Yes, Mr.
counsel
Boni.
died.
Yes.
My lord, this is a case of section 129 of CGST Act. 129 1
He says he prays for releasing upon furnishing the bank guarantee for the amount. Whether you are agreeable.
No,
Why? Bank guarantee he files.
We have already issued replied their letter, which was issued in the month of September. On 7th October, we have sent a reply to the SSC that you the documents which you have placed before the authority, and after investigation, it was found that you are not the owner of the goods. And when you are not the owner of the goods, in that case, 129 1A will not be applicable in your case. You can deposit the amount as per section 129 1B, wherein it is categorically
Bank
mentioned.
guarantee cannot be accepted.
Bank guarantee, we can accept the bank guarantee.
He is saying that.
But according to the as per section 129 1B,
Yes.
129 1B says
Goods have to be released to the owner.
129 1A on payment of penalty equal to 200% whenever the owner of the goods comes forward. 129 1A.
and 129(1)(b on payment of penalty equal to 50% of the value of the goods or 200% of the tax payable of such goods, whichever is higher, and in case of
Where
exempted.
the owner does not come forward.
Yes, where the owner does not come forward.
Yes.
Yeah. মেলটা দেখিয়ে দাও মেল একটা প্রিন্ট আউট করে দাও just few minutes back we have received the mail wherein order was passed that we can release the goods on payment of rupees as per section 129(1)(b).
My lord, that is a challenge. That is a challenge.
129(1).
All right, so I'm keeping it before the next circuit.
My lord, may
Due to
grant me the
paucity of
liberty.
time, due to
My
paucity
lord,
of time.
My lord, then
this
liberty
matter-
may be
just
given
grant
to
me a
move before the
liberty to
Calcutta High Court, my lord.
before the Calcutta High Court.
List this matter before the next available
My lord,
circuit.
can
My
it be
lord,
moved
please,
before the Calcutta High Court
Yes,
bench,
my
my
lord.
lord?
Please,
If the
my lord.
liberty is
It's a very
after
urgent
1 week.
matter. My lord, I am covered by the CBSE circular by the.
My lord, there is an urgency. That is my lord. This
My
matter
lord,
is
The order was
hanging.
passed, madam.
My lord, after we have received the after we have
When
given
you
the
have received the order?
representation, we have filed.
When the order goods were intercepted, madam.
My lord,
My lord, the
31st.
goods
Then we
was-
have written a
31st
letter.
of
July, my lord.
31st July.
Then we have written a
1
letter.
week you can
My
wait.
lord, no, they
Yes,
have not
on this matter.
uploaded the order. My lord, the limitation has not started. They have not uploaded the order till date.
All right, it will appear.
Let
on
the
Friday.
liberty be given, my lord, to move before the Calcutta bench, my lord. Because this was initially filed in Calcutta bench, then it has come.
1 week, nothing. Because the Calcutta bench has said there is no urgency. That's the parent order. Yes, next. Yes, what is this matter?
For the private respondents, yet to receive a copy of the brief. I have not been served with the copy of the writ petition as of yet. I have come to know from yesterday's cause list that this matter is posted.
No, this was appearing in the list.
Yes, but I was not served with a copy of the writ petition. Never served with a copy of the. And for the private respondent.
Sawmill license have been cancelled, my lord. This case.
Yes.
My lord, the present petitioner is running a sawmill, my lord, and his sawmill was cancelled. The license was firstly suspended because they gave an complaint letter before the DFO.
Joint license.
He's a joint licensee. They also have a partnership firm, and they had an objection that this license cannot run. The sawmill cannot run, my lord. Accordingly, they first filed a writ, my lord. The writ is in page number 58, and an order was passed to give a proper hearing and pass a reasonable order, my lord.
Yes.
Second round of writ petition. Previously also the said petitioner filed.
So there was a direction to pass a reasoned order.
That was passed.
Then
That has
you have passed an order.
Number 60 is the recent order, my lord.
Yes,
And
then
my
it is challenged under in this writ
No,
petition.
thereafter they filed an appeal, my lord. That's in page 69, my lord. That was affirmed.
Oh, this is against that. There is a provision for appeal.
Yes, my lord.
Yes.
And thereafter they have filed this writ, my lord.
No, where is the order passed by the appellate authority?
My lord, that's in page number 69.
69. Yes. So the appellate authority has affirmed this order.
From the order, because they have given an objection that they are all the owner of that land, my lord, and they have an objection that
Respondent number 6 is not the owner of the land. Yes, the husband of the respondent number 6 is basically the owner of the land, and
Your husband is the owner of the land.
and he has given
And your husband and the petitioner were partners of the sawmill.
I and the petitioner are part.
the wife.
Oh,
It was previously in the name of my basically
Father.
father-in-law. So subsequently it was in the.
now this order passed by the appellate authority is under challenge.
Yes, fine.
In this writ.
In this.
Yes. Yes, when there is a dispute between the partners in a partnership firm, so how can the license be revived? Cannot be revived.
When no accounts have been provided, several letters have been issued by me. to the-
Partnership firm, if there is a dispute between the partners, what have you paid for? Madam, yesterday it was passed over also.
So this is also binding on the suit property itself. There's a civil suit against court and court of the marriage civil. Filed by the husband of the respondent number 6.
So Mr. Mondol is a busy counsel. He is expected to remain busy in one court or the other. You are the advocates. You have to be ready. Yesterday it was called on. It has been adjourned and it has been fixed today. So the license has been suspended.
Firstly suspend, now it is cancelled.
Now it's cancelled.
Initially, it was suspended by the DFO. Subsequent to that, it was suspended. They have challenged that order. They have, the perspective thereafter was.
Then file your affidavit.
upheld it.
Ashok.
It has been stated that both parties are directed to resolve their dispute within 1 month from the date of the receipt of this order. That's
Yes,
why.
if they resolve their disputes,
I
then
have tried a number of times, followed. I have even issued letters to the other partner. No
There is
response.
one point,
Yes.
as per my knowledge, 18 lakhs of rupees has been
totally
given to
false.
the opposite opposite party for the settlement. This is also annexed in the petition, Lordship. But still they did not hand over the transfer the name. Lordship, this kind of
this is an interstate dispute
There's no question of
between the two, between the partners of the partnership firm. Now the license was in the name of the partnership firm.
Yes.
So if there is a dispute between the partners, so how can a license be renewed? It has been cancelled. You resolve the disputes. You resolve the disputes, approach the authorities. So now you cannot be allowed to run the interim. There is no scope to pass any interim order. Let them file affidavits. The petitioner has challenged the order passed by the appellate authority dated page 69.
69.
Dated March 5, 2025, thereby refusing to interfere with the order dated, where is the initial order page? 5th of February, 2025. No, this was suspended. Sarkar, this was suspended.
Firstly, it was
Firstly,
suspended.
it was suspended.
So against that suspension, appeal order was passed. Where is the order of cancellation?
But it is not cancelled. The impugned order is at 69, page 69.
Yes,
And
that has affirmed the order at page 61. 61 says suspension, not cancellation.
Lordship, there is a partition also. They made a partition deed, and as per the partition deed, it is not mentioned which portion belongs to which.
Absolutely
And
false.
Get
Absolutely. There's a suit pending.
final degree of
There's a
partition.
status quo.
Final degree has been passed in
No,
the partition
there's a
suit.
partition
No,
suit,
Lordship,
my lord.
it's pending.
It's not a
We have
partition
annexed,
suit.
we have annexed, we are not
suit
suppressing
the-
anything.
My lord, it's not a partition suit.
Whereby
As
the
written by the deed, registered deed.
sawmill license in favor of the partnership firm was suspended. Full stop. Considering the nature of the disputes raised in this writ petition, this court feels that the respondents should be afforded an opportunity to file their
Your
affidavit
lordship,
in
I appear for the
opposition.
petitioner, my lord.
Yes, Mr. Mondol. Let the affidavits
lord,
be filed.
My lord, one thing, my lord, from February, my lord, my business has been shut down on the ground. My lord, the main crux of the complaint is that I am carrying the sawmill on the land of my brother, which has been partitioned. On the face of the record, there is a partition suit pending before Jalpaiguri District Court.
Mondol, please hear me.
My lord.
So the order of suspension is under challenge.
Yes, your lordship. Yes.
Appellate authority has affirmed the order of suspension.
Yes, unreasoned order. Your lordship kindly sees
Mr.
absolutely
Mondol,
unreasoned
I
order.
appreciate unreasoned everything, but rightly or wrongly, there is a dispute between the partners. There is a partition suit also pending.
Yes,
So all
yes,
these
yes,
facts,
yes.
there is no scope to pass any interim order. If that
No, my
is
lord,
interim order is
may I
passed,
be permitted to, my lord, may I be permitted to run the
no,
sawmill?
no,
My lord,
Mr.
it has been
Mondal,
running from
Mr.
1989.
Mondal, interim order to that effect, what you are praying would ultimately allow the writ petition at the stage of admission. What are you submitting? You are well aware of
My
the
lord, only
provisions
one
that
thing, my
cannot
lord,
be done.
my lord, as on today, my lord, the partnership deed is subsisting.
Mr.
Private
Mondal,
respondent is also a partner, your lordship.
Mr. Mondal, ILR 1994-1, Calcutta, page 72, in re Gautam Kumar Hada. It specifically says no interim order, which would ultimately have the effect of allowing the appeal.
Absolutely, your lordship.
Yes. So you
My
are
lord,
aware
yes.
of those provisions.
Yes,
So I'm
yes, my lord, I am.
directing them to file affidavits. I will consider that.
But this is
Yeah.
not a particular suit, it is for recovery of position filed by
Kyo na?
the husband of the.
কি বললাম? Unless an opportunity is granted to the affidavit in opposition. Full stop, let affidavit in opposition be filed within a period of 3 weeks from date. Reply there to be filed within a period of
My lord,
2 weeks.
2 weeks, your lordship, yes.
2 weeks thereafter. Full stop, parties will be at liberty to mention this matter. For enlistment.
My lord,
and
only one thing may I submit.
After the expiry of the period fixed for exchange of affidavits.
My lord,
There is তার আগে একটুখানি লিখে দিন।
My lord, only one thing may I submit.
Has prayed for an interim order allowing the petitioner to run the sawmill pending disposal of the instant writ petition. Full stop. The order suspending the sawmill license is under challenge in this writ petition. Full stop. In view thereof, there is no scope to pass any interim order as the same, if passed, would amount to allowing the would amount to granting the final relief at the stage of admission, which is impermissible.
My lord, only one thing may I submit, my lord.
I have not been served.
Petitioner is directed to serve a copy of this writ petition upon Mr. Raman, learned advocate, appearing for the private respondents. In course of this day, madam, can you not serve upon him?
I served, but it is returned to the sender.
Please serve a copy. If it is service filed in court today, is taken on record. Can serve in course of this day. In course of this day. Yes. Next, call the next matter. Item number 25. Yes, 25. Yes, Mr. Ghosh. What is the application?
Milord,
You wanted the application to be.
yes, only the application, Milord. Milord, under
Within
grave,
2 minutes.
Which
Milord,
application, my
under-
lord? We do not know any application.
Milord, it has been.
He has mentioned, he has said some application.
Yes,
Application
Milord,
is only
yes.
being listed.
Milord,
I
the
do not-
We
application,
do not know any application.
No, I have
Milord-
also not. I also do not know what is the application.
Milord, yesterday at 6 p.m. after your lordship allowed the mentioning, Milord, it has been mailed to Mr. Chaudhary and his juniors.
Chaudhary,
হ্যাঁ আপনি
you cannot serve me because you have to serve to the
in the
office of additional government pleasure.
in the mail of
Mr. Ghosh.
AG High Court.
Mr. Ghosh, what do you want?
Milord, I can hand up Milord a hard copy right now if Mr. Chaudhary accepts. Now, Milord, the
What is your
application,
prayer?
application, Milord, is a very innocuous prayer. Milord, kindly takes the order of this court of 1st February 2024 passed by Justice Sinha.
1st February 2024. Yes.
2024. Milord would find, Milord, I prayed for an interim order and the court, Milord, there was a undertaking, Milord, recorded on behalf of the state that my remaining 1250 acres of land shall be kept encroachment free. Now, since February 2024, Milord, state has not filed their affidavits, number one. Number two, Milord, yesterday, day before yesterday and yesterday, at least till 3 p.m. yesterday, Milord, at least 11 individuals claiming themselves to be the representatives of the land department as well as the national highways. Milord, they came to my property, Milord, an area which is under tea cultivation. Milord, they're trying to, Milord, they're doing some measurements, Milord, soil testing, etc. is going on. Milord, my prayer today is only, Milord, as per what they have said. 1250 square feet acres of land, Millet should remain encroachment free till the writ petition is
That has been,
decided.
that order is there.
That is being violated. Millet, let
Let a contempt.
Ghosh, if there is a violation, you have to take out an application for
Millet,
contempt.
Millet, my
So this order is still there.
This-
So if
this-
there is a violation, you have to take out an application for contempt.
Millet, Millet, my only prayer today, Millet, let Millet at least some protection be granted so that they don't do any further encroachment. Millet, once tea
Mr. Ghosh,
bushes
there
are
are two
uprooted,
things.
Millet, once tea bushes are uprooted, my contempt application cannot bring back my tea bushes which are there since the last 50 years. It is very easy to for Millet the state to say go file a complaint, contempt, whatever. But for me, once it goes, it cannot come back. Millet kindly protects to that extent.
That protection is there. There will be no encroachment.
Millet kindly,
But order can
Millet,
I pass now?
kindly Millet observe, so far as 1250 acres are concerned, which is recorded in the name of the petitioner company today, although the lease is pending, Millet, there will be no affectation of my tea bushes and shade trees. That's all. That's all. Millet, that's only that limited portion, Millet, because once that goes, Millet, that will not
be
come back.
amounting to modifying the order.
It's
No encroachment means that.
Millet, the other way to look at it, Millet, it would be Millet elucidating or elaborating what has already been granted.
First of all, that I do not know what is the content of the application which has been filed, what they say.
Yes.
Now, my lord, if your lordship see from the online, it is seen that the date is given on 17th of November.
For what?
This application, which has been filed yesterday.
Date is given on
17th November.
Yes, to
on
be
the online,
around
my lord.
17th.
No, that's what the department
17th,
automatically
number
grants a
one.
date.
Number two, my lord.
That's why, Millet, I have mentioned it before your lordship.
This is your date. This is your date.
Millet, the department specifies a date to be mentioned. Millet, it's not in our hands,
Yes,
not in the hands
yes.
of the advocate and record to change it.
Yes, you
That's
mentioned.
the purpose, Millet. I was waiting for your lordship till 5:30 PM to mention this. That is the reason. It is not in our hands. Millet can inquire it from the department. Millet, we are directed, the on records are directed to specify a date after 48 hours. We don't have a choice over there.
Then, my lord, if the situation is like that, then the the copy is required to be
No,
served.
only one thing.
My lord.
Mr. Additional, please take. Do you have a copy of the? Please give him a copy.
Millet, I have-
Please look at the prayers at page 7.
Prayer.
Yes, prayer at page 7.
Yes, my lord.
So
Have
to
to pay
stop
direction.
making any encroachment, that interim order is already there. So you cannot say that or that you are violating.
Doing anything.
And yes, next pair B is police authorities to keep a strict vigil. So I'm directing the police authorities, you will not be affected because you are not encroaching.
Yes, that much
I'm
will
only
suffice.
directing the police authorities
Yes,
to
yes,
keep
that
a
much will
strict vigil.
Yes.
Yes.
And that order is there.
My lord, kindly.
I will
appreciate-
record your submission that there is no
kindly-
encroachment.
Kindly appreciate this tea estate without the renewal of a lease agreement. My lord, kindly.
I appreciate that.
No,
There
my
are
lord.
two things. If you say, no, this order ought not to have been passed. So
No,
now
I'm
as
not-
on,
I'm not saying.
so
My lord, the question is that, my lord, when there is a order staring at our frame, my lord, when I say that there was no further, my lord, encroachment, then, my lord, what remains?
no, I will not pass any order with regard to encroachment. I will record that that order is there and I will only direct the police authorities to implement the order of the court.
Absolutely.
That the police authorities
Yes.
are duty bound to do.
My lord,
Yes.
Kindly see the report then, page 25.
To
Annex at page 254. Communication of the 2nd January 2024 in the writ petition.
254.
Yes. I put the bill.
Yes. To comply with the department's order such and
My lord,
such.
I will just, my lord, kindly for a moment, my lord. The matter went to the Honorable Supreme Court. Supreme Court did not touch it.
No, Millet.
Please allow me to.
No,
Mr. Ghosh, please allow him to
No,
submit.
Millet, I'll give your lordship the background.
Yes,
If
please,
I am
please.
incorrect,
No, please.
if I am incorrect, Mr.
No,
Chaudhary will correct.
when
Millet,
I am at
originally-
Supreme Court,
Mr. Ghosh, allow him to make submission. You will be getting a chance to reply.
Millet, Supreme Court did not touch it. Millet is an
Mr. Ghosh,
incorrect statement.
Mr. Ghosh, you will
I'm
be
sorry.
getting your chance
I'm
to
sorry,
reply.
I'm sorry.
Please allow him to make the submission.
I'm sorry.
Yes.
so, my lord, kindly come to 254. Yes, my lord, the undersigned is there to refer the above subject, request him to comply the department's order of 3rd January 2020. in relation of a long-term lease of 1250.64 land comprising amalgamated Raja Tea Garden, district Jalpaiguri. Now, 3rd January 2020, my lord, kindly see.
Is the next page?
No, my lord, just a
No,
second,
3rd January 2020. Which page?
my lord, just a second. Just, my lord, suddenly, my lord.
Yes, 3rd January is page 223.
Yes, right. My lord, sorry, my lord,
Yes.
kindly see. 3rd January is what is the order, my lord? I am directed to refer subject land. Governor is pleased to hereby accord area more or less 1250.64.
Yes.
That excluding the area comprised in certain such Miller Obijit Tea Company for 30 years with effect from 22/2003. Miller kindly Magate.
Yes.
Subject to payment of salami 9,000 per hectare in term for 60 days and the department rent and up to date rent and cesses for the purpose of running the safety garden.
Yes.
Now, my lord, paragraph 2. Now, what is this paragraph 2? It is accordingly requested that on realization of first installment of salami and up to date rent and cesses, the lease deed as per modified Form 1 Schedule F to the amended West Bengal State Acquisition Rules such and such prescribed in duly inserted the verified land schedule should be executed in duplicate by the collector Darjeeling for on behalf of the governor of West Bengal and the director of Obijit Tea Company Private Limited with 2 witnesses on receipt of such. West Bengal. Thereafter, they executed lease deed should be placed before the district sub-register additional details. So there was a 2 components. First of that, the 2003, the lease deed, fresh lease deeds to be executed from 2003. And in addition to that, the lease deed salami.
Yes,
and the
that
rate
have
to
to
be
be paid. Yes.
Now,
At a defined rate.
And thereafter, my lord, if you lordship see, there is a division bench order. There is an order, my lord, that if such payment is not made, then the department is free to take appropriate steps in accordance with law. It is there also. We are in 2025, end of the 2020. As of now, my lord, this salami, they have not paid, and consequent thereto, my lord, the lease deed could not be executed. With this backdrop, my lord, this repetition was filed that they are not allowed, they are not entitled to pay the salami because it is not a fresh amounts to a fresh lease of lease to be executed. So in this code, on the basis of that, because this land, thereafter, there are governmental the further projects to be undertaken in and around excluding 2.50 what is the land prescribed. That's why we say still we are ready to comply that unless they make a payment, this deed cannot be executed. And this the moment, definitely we did.
What is the challenge in this writ petition?
Kindly see the prayer. Prayer at page
22.
Actually, long back I read, so I just missed something, my lord. Paragraph page 22.
Yes.
This
is the communication dated 2nd of January 2024.
That is which 2nd January 2024, which I have shown just now. But the
254. So 254 says
yes,
that request him to comply with the department. So it says 3rd January 2020. So they have to pay that salami and other things. So that they have challenged.
Yes. Now,
whether they are liable to pay that salami, that's the subject matter of this writ petition.
Now, P. See the P.
There are two limbs of challenge.
Forthwith necessary step for grant of renewal of lease in favor of the petitioner company for an area of 12.51.14 acre. After deducting the initial acquired chunk such as that area measuring 44.37 acre from the original leasehold area.
So it has been reduced now.
It has been reduced. So, now thereafter within the land, is a government land. As I indicated, there is the court building is also to be Malbajar court is also established a portion of that adjacent to this the place. So there are the hospitals and the government below the projects were undertaken, excluding this area, Milord. There we have not touched even, despite they did not. Now there was this is the reason, Milord, in the first January 2024, Milord, this is the order was passed that still, Milord, if this subject land is salami and the other dues are paid payment, then definitely least can be executed. So now the prayer in the writ petition, Milord, or sorry, in the Milord application which they have filed yesterday, the prayer, Milord, kindly see that prayer is A, as your lordship has seen, that
Yes.
appropriate reactions are necessary to each of them to stop making any encroachment. So
That
we-
you are, that
now
you
the
say you are
after
not doing.
appropriate deduction upon the respondent of the particular respondent number 4.
Yes.
The ADM and district land and land reforms officer.
No, respondent number 4 is
ADM.
ADM to forthwith direct the local police administration to keep a close
no,
vigilance.
police is not a party.
No,
Police
Milord.
is not a part
No,
because
Milord.
originally in the writ
Milord,
petition the police was not a
The
party.
forthwith respondent forthwith direct the local police to take the vigil over the steps. Milord, we are the district administration is taking care of this land, Milord, state's land, and even at the same time, Milord, we are also very conscious about the plight of the workers. This is the reason, Milord, we have not determined, Milord, we have not cancelled, we have not called for the further, Milord, for a engagement. So as of now, Milord, my still undertaking is stands remain, and I being the officer have given this undertaking. Now, Milord, question is that enforcement of the order, Milord, that already been enforced, Milord. Even, Milord, out of the way, Milord, day before yesterday, Milord, there was a visit from this honorable court of this, Milord, for this, Milord, this area of this Malbajar court is functioning and all. Then also it was found there are certain illegal encroachment in the court premises, Milord. My district administration was advised to deal the matter immediately, Milord. So this doesn't relates to this land or the tea estate, Milord. So the police authorities, Milord, the implementation of the order, Milord.
When an order has been passed, police
I am
authorities.
saying, Milord,
if-
I am saying, Milord, this is my mistake, because there are so many matters pertaining to this tea estate. I filed a petition with other, but I missed somehow. Just now I was talking.
No,
with my-
all right. So I'm giving you liberty to file an affidavit. No issues
Yes,
on
Milord.
that. Now, only one thing with regard to encroachment and restraint order is there.
I'm asking myself, without a sanction of a deed, which is yet to be, Milord, executed,
Milord,
they have any right accrues over the, Milord?
Mr. Additional, I cannot go into that because there is an
This is the
subsisting order there.
Milord, the
So
application, Milord,
when
I
the
will-
order
I-
is there, unless it is modified or varied,
Yes,
you
Milord.
cannot say that no party. I'm not saying you. No party can say that they will violate.
Yes.
Now there are two issues.
Yes.
Now when an order is there, the police authorities are duty bound to obey the orders of the court.
Well, this is a police authority, the state administration. Police comes within that.
Yes.
The state administration is duty bound to execute, obey truly, effectively each and every word of this code.
So if you say that I'm recording that
Yes,
the
record.
respondent.
I
number
will
four,
be held.
yes, I record
No,
your
Milord,
undertaking.
let it not be, Mr. Chaudhary, not required. Respondent number 4, Milord, direct respondent number 4 to comply the order in its letter and spirit. That's all.
The respondent authorities, not 4.
4.
Not 4.
The ATM
All. He says all.
State machineries are duty bound.
Milord, I am saying this for a purpose.
I'm recording his submission and directing the.
I say, whatever the undertaking was given on the basis of an instruction received from my department, Milord. This is the reason why I say, Milord, that state authorities are duty bound to execute this or
Yes.
comply the order.
Yes, Milord, respondent number 4 is in session of the matter. Whenever encroachments are happening, he is visible in the spot. So I am, Milord, let there be a responsibility on a responsible.
So I'm directing if
Respondent number 4.
if any case you make you allege anything with regard to encroachment, you can make a representation to the block landowner. He can approach the block landowner or which authority will be better.
Respondent number
If
4.
there is an allegation of encroachment.
Rather, I will say to the district magistrate.
All right.
Why ADM not?
All right. I'm.
He has been newly joined.
So district magistrate, Mr. Ghosh.
He is,
Milord, I
he
would-
is the
Milord,
supreme
Milord.
in the district.
All right, but the difficulty, Mr. Chaudhary, will be that will be in the district, and the BLRO will be the person present at the spot.
Milord, then
And,
BLRO,
and BLRO knows the extent.
Milord,
He
that
is the best person.
BLRO, I have no.
I think BLRO will
BLRO
be the
will
best.
deal the matter as and when such
BLRO is respondent number 5.
Respondent number 5.
BLRO.
ADM is the
Respondent number 4.
All right. But your prayer is respondent number 4.
My lord, we have prayed that let the respondent number 4 be directed, my lord, to to direct the police.
Who
to
will
keep-
be, who, no, not the police. If any case, I'm giving you liberty in case of any encroachment is made, you can approach that authority.
Yes.
And that authority
shall be duty bound to comply with the
Yes,
order of 1st
exactly.
February. Yes.
But I'm asking you which authority will be in a better position,
5?
4 or 5?
5.
ADM district land or I
ADM
think
is,
BLO.
ADM is sitting here.
Yes.
5 is in the.
I think BLRO will be the
My lord,
best person.
my lord, let it be 4 and 5 both. Why I am saying this? My lord, why I am saying this?
There's a
Mr.
conflict.
Ghosh, then you have to approach both. It will be a difficulty because he is sitting in district. I will choose only one.
My lord, so far as this area is concerned, my lord, it is the respondent number 4 who is directly overseeing the entire thing.
Alright, I can direct this respondent for. He
Yes.
has no.
My lord, why
He is
Mr.
not
Chaudhary will
opposing.
have
No,
a
he is
problem?
not opposing.
He has no
I
problem.
said the effective
No,
implementation.
he is not opposing because my idea was that the block division
Generally-
will be in a better
generally,
position
Millard-
because he
Millard-
will be available
Millard-
in the locality, the
Millard-
block.
Generally, my lord, your lord, what has fallen from your lordship is the correct view. But my lord,
He is not opposing. Yes, I
I said for
directly.
effective implementation.
my lord, I am saying for effective implementation, it will be
Alright.
respondent number 4 in this case.
This, then I'm disposing of this application.
Grateful, my lord,
Yes.
it can be.
And Milord, kindly deprecate the way the application is being served through my personal email or my official email.
Mr.
Because
Ghosh,
it is not the way to
yes,
serve.
personal email should not
No,
be
no, no,
served.
my lord,
Maybe
it's-
you can serve in the office.
No, no,
Yes,
Millard,
in the
it's-
personal.
It's not personal email, Millard. This is AAG High Court JPG at gmail.com. It is his official email.
Official email ID.
So, what for the official email ID is
Official
that?
email ID in the evening, my lord. Your lordship knows the infrastructure here in the circuit bench, my lord. So at least, my lord, the off should be served upon the AGP. My lord,
Mr. Additional
even
Advocate,
my lord.
sort it out amongst your members with regard.
No, it is not.
Millard, let them.
It is
Millard,
not sorting out.
Millard has
It is-
observed throughout the circuit with regard to service, Millard, different views are coming up.
No, I have the.
Millard, let the office of the government office, Millard, issue a notification, the email IDs, and in case of urgency, who is to be intimated.
Mr. Ghosh, there are some issues also. There has to be some specified time because they are creature of instructions.
Correct, I
So
understand.
you have, Mr. Ghosh, you have direct contact with your client at any point of time.
They do not have.
They do not have. So let us assume that today at 6 p.m. you serve a copy in his mail ID. So after he has to
No,
see that, then he has to take instructions. Unless
Well,
he
it is
takes
the- it is the
instructions,
official
maybe
mail ID.
Absolutely
maybe
correct.
he will be physically
Millard,
present, but
absolutely
he cannot
correct.
assist the court.
But Millard,
The
absolutely
addition
correct.
that-
But Millard,
My advocate
if
record.
someone, Millard, if someone wants to move a writ petition unlisted, grave urgency, your lordship says, yes, this will be heard by granting an AST number. Millard, in those urgent situations, there has to be a mode of communication.
No, my lord, what happened, my lord? May I just indicate when this issue is
That,
raised?
Mr. Ghosh, that I'm taking care of that, or the court takes care of that. In many matters, I'm requesting the additional advocate, the additional government pleader, Mr. Pal, who usually appears for the state, even in cases where the copies are not served, I'm requesting them to appear to take instructions. They are coming. I think in one of the matters, yesterday it was taken up. I've directed them, and Mr. Shah and Mr. Pal has taken instructions, and today in the morning they have come with the
But
instructions.
Yes, yes, yes.
They are also
There is no
cooperating.
doubt about it, Millard.
But they have to be
Please,
given
madam.
some time. They are also cooperating. They are accepting the
No, no.
briefs.
Absolutely,
then and
Millard,
they are
we have no dispute with this.
Office is in Darjeeling. My lord, kindly see
at
how the
times
additional
it
government
creates
has
an-
taken effort.
And this happens in hotly contested matters, Mr. Ghosh. Everything.
My lord,
Your
Mr.
client
Ghosh, it was in our side for last 4 years. So it is.
now Mr.
Our
Shah
side or that
appreciate
side
because
is not a question.
no, he is
Question.
representing his client.
No,
He is
always.
answerable to his
Yeah.
client. He has to
But my lord,
make
my
submissions.
only submission, even in some matter where the matter is in extreme urgent in nature, only my intervention is sought for.
Yes, yes.
In these circumstances, my advocate record is there, by the other junior advocates. Then why? Because this is my official communication mail ID. I am not supposed to receive any petition or application.
Yes, Mr. Ghosh, he is.
That-
Millard, at the
But
time of mentioning,
because
Mr.
he is
Pal
not-
and Ms.
he-
Sarkar was present
no,
in the
he is-
court.
He is not appearing alone. So he is appearing with a junior. You have to,
Inko-
you could have served upon his junior.
My office is Millard,
Only
that
the official
respect should be given to my office. Maybe we don't have any.
Mr. Ghosh, you should have, yes, he is right. You should have served upon his junior, not directly.
His junior has also been served, but I must be candid, it is not his junior from the state panel, it is his chamber junior who has been served.
Chamber junior.
Should not,
No,
should not.
Who is appearing because you are happy, you are aware.
Mr.
who
Pal
is-
was there in the court.
So you should have served him.
Yes, well, that is a mistake. That's a
Should
mistake.
have served him
my lord,
because
my junior
directly.
intimating that night, my lord.
Because the advocate general, the stature of the advocate general is not expected, may not appear in all
No,
matters.
I understand,
His
Millard.
discretion in which matters-
Mr. Pal or Mr. Sarkar should have been.
It's indicated. The one mail has come. I said, don't open it. Because you are not authorized, even it is sent to you, you are not authorized to, my lord, to see the contents of that. And that, my lord, secrecy and the, my lord, the transparency I maintain, and that's why I said, you may know, don't touch. So this is the
Yes,
way-
when the junior is there.
No, Millard, this is a mistake.
Senior,
Mr. Paul.
generally service is not paid, not even to the advocate general or the additional advocate general. Even in case matters where the seniors are appearing, service has to be affected to the advocate.
No, that is, Millard, that is a mistake. That is a mistake. Millard, I
So-
submit that is a mistake.
Yes, please
Mr. Paul
ask your,
should have been served.
ask
I
your
agree.
juniors to make this, not to repeat this, because Mr. Chaudhary is taking a serious exceptions and he is right in taking that.
Millard, he is right.
Particular,
Millard, he
because
is
why I am saying.
No, I appreciate.
In this particular,
Ashok, this application, this matter was, this application code, CAN 1 of 2025. This application was mentioned by Mr. Ghosh, learned advocate for the petitioner at the rising of the court yesterday, bole kalke date diye deben, citing grave urgency. Full stop. Considering the urgency pleaded by Mr. Ghosh, this matter was directed to be listed today under the heading application. Full stop. When this matter is taken up for hearing today, bole aajke date, the learned additional advocate general appears and submits that he could not take complete instructions with regard to the issues raised in the application due to paucity of time.
It has not been served.
As the same was not served upon the learned advocates assisting the additional advocate general. Full stop. Mr. Ghosh, learned advocate appearing for the petitioner, submits that through inadvertence, the learned advocate assisting the additional advocate general could not be served, and by mistake, shall I record? It was sent to your person.
No,
Full stop.
not required.
ঠিক আছে? Advocate was not served. Full stop. Paragraph. When this matter is taken up for hearing, a copy of the application has been supplied to the learned additional advocate general. Full stop. The petitioner has alleged that in spite of an interim order passed by a coordinate bench restraining the restraining na kore, observing that there will be no encroachment in respect of 1250.64 acres of land
In terms of the communication dated 20th January.
pursuant to the communication dated
2nd January.
2nd January 2024. The respondent authorities are attempting to encroach upon the portion of the tea garden, to encroach upon the aforesaid portion of the tea garden in violation of the order of injunction.
A portion of the ceiling.
A portion of the said area. A portion of the said area.
Not entire.
Not entered.
A portion of the aforesaid area in violation of the order of injunction. Full stop. Such submission is seriously disputed.
It's injunction.
No injunction. That is why I have recorded observation.
Yes.
That I have recorded that. The learned additional advocate general submits that there is no violation of the order dated 1st of February 2024,
And even there is no attempt even.
and there was no attempt to encroach upon any portion of the of one of the aforesaid 1250.64 acres of land, as mentioned in the aforesaid communication dated 2nd of January 2024. Full stop. In this application, the petitioner has prayed for an order directing the respondent authorities to stop making any encroachment activities and to pass a direction upon the respondent number 4 to forthwith direct the local police administration to keep a strict vigil so that no further encroachment takes place. Full stop. Since the order dated 1st of February 2024 has protected the right of the petitioner insofar as the allegation of encroachment or in respect of 1250.64 acres of land as mentioned in the communication dated 2/1/2024 is concerned, this court is not inclined to pass any further restraint order. Full stop. That is why I've said no further restraint order. Full stop. The learned additional advocate general submits that it is the duty of the respondent authorities to obey the orders passed by this court. Full stop. Such submission of the additional advocate general is placed on record. Full stop. It is observed that in the event the petitioner in the event it comes to the notice of the petitioner that any attempt of encroachment is sought to be made, it will be open to the petitioner to make an approach the the additional district magistrate and district land and land reforms officer Jalpaiguri being the 4th respondent by submitting a representation in respect of thereof. Full stop. Immediately upon receipt of this said representation, the respondent number 4 shall take necessary steps and ensure that the order dated 1st of February 2024 is not violated in any manner whatsoever. Yes, with the aforesaid observations and liberty being granted, application being such and such stands disposed of.
One in that is the time period of filing of video should be extended.
এটা হচ্ছে ক্যানটা ডিসপোজড অফ এবার রিটেতে দ্যাট ওয়াজ ইন দ্য রিট পিটিশন WPA তে একটা অর্ডার রেকর্ড করুন on the prayer of the learned additional advocate general, time to file affidavit or reply.
Opposition.
No, opposition or the report.
Opposition.
No,
Time to file the affidavit in opposition is extended till
3 weeks, my lord.
2 weeks.
3 weeks.
3 weeks.
Mr. Pali is saying 2, I said 1, take more extra week.
On or before November 20, 2025.
Yes. Lordship,
Oh, no, that will be 2 weeks.
2 weeks.
On or before November 27, 2025.
Circuit to 17th.
17th.
From 17th, I think it will end on
28.
28. So next.
Reply
So
me
by
like 1
30th
week.
November, we will file. We'll file it. In the meantime,
Reply within 1 week thereafter.
then in December circuit, you can use it.
27, full stop. Reply thereto if any be filed on or before December. When will be the next circuit?
15th December.
15th থেকে বলে 15th.
15th. So on or before December 8, you will be getting another
Yes.
Sunday. On or before December 8, 2025. Parties will be at liberty to mention this matter before the appropriate bench for enlistment under the heading hearing.
5 দিনের circuit. Here is that circuit is below from 15 to 23rd. The five.
Yes, where is the passed over matter? Yes, Mr. Sarkar.
My lord, I am for the petitioner in item number 20, my lord.
Yes, what do you say?
This is the, I think, my lord, first time that the last day of the circuit is being extended till 140.
My lord, may I?
Your lordship,
Thank you. Yes.
My lord, may I? One thing I missed out, my lord. I issued I got the show cause notice. Subsequently, order under section 73 was passed. And this order that was passed against me is clear by clearly violating section 16 subsection 5. Yes, order is there, my lord. It has clearly mentioned, my lord, what is the.
Where is the order?
Yes, it has been there, my lord, at page number 28, my lord. Page 28.
Page 28.
Entire order is there.
This is a summary order. Where is
No,
the entire order?
Page 30, my lord.
Page
From 28 I annexed and actually at page 30
is the order.
Yes, there, my lord.
Yes.
Now, this order has been passed by clearly violating section 16 subsection 5 of the CGST Act, my lord. And here also, my lord, the last date last date of filing of GST 3B was 30th November, my lord. 2021, 30th November, my lord. The circular is also there, my lord. Kindly come to page number 33 of my writ petition.
Yes, Mr. Sarkar, what do you say?
Subsequently, my lord, one more thing happened, my lord.
Time was till 30th of November 2021, and you have said you have taken action by saying 20th of October, it was not filed.
Moreover, my lord, I filed an application under section 148 of the CGST Act for rectification of the order. That too has been kept pending. And they have issued an order against me, and they're trying to, my lord, actually they're trying to grab my entire business capital from my bank account, my lord. Kindly.
Yes, Mr. Sarkar. What is your submission?
It not appear when the appeal order was passed.
Maybe, but if there is a violation,
Documentary proof one. Like for example, he says that he is liable to get the ITC as per section 60 because
no,
the
he
supplier.
says, he says those are on mates. Please show me that show cause notice. Where is that? You have pointed out that
I have annexed the show cause notice, my lord. It's starting from page number 18, my lord.
yes, page number 18. No, where is that? That date was mentioned 20th of
At
October.
page number 22, my lord.
22.
Point number 4F.
Yes,
Last
ITC availed in GST 3B filed after the date prescribed under section 16(4). That is, that have been filed after 20th of October 2020. So according to you, it ought to have been filed before 20th of October 2020.
The circular says something.
Relying upon this section 16(5) says that the last date is 30th of November 2021. See, if that is so, that is in violation of that.
Those are documentary proof, my lord. Those are required
No,
to
no,
be seen by the
No,
department.
no, it's your department's this noting.
That's why I filed section 148 application. That too has been
That's
kept
your
pending.
noting that it is 20th of October, assuming you could not have fixed 20th of October.
Yes,
This notification or this section has was amended, my lord, and brought in, my lord, in 16(5), my lord. I do not have that in my.
All right, do one thing, because he has filed an application for rectification.
That is to be considered.
So I'm directing you, don't take any coercive steps
Yes,
till
my
that
lord.
time.
That's what.
Where is the application for rectification? 148, where is that?
At page number 38, my lord.
38.
38. And these two also have been made within the time limit, my lord. Page number 38. From page number 38, I have annexed.
Yes, so how soon can you decide this?
At least 3 weeks, my lord.
So opportunity of hearing also has to be given.
Until then, my lord, no coercive step and deduction of my money.
This is rectification of the order dated 28th of August 2024.
Lordship.
The petitioner has alleged, the petitioner has alleged that the order under section 73 within bracket 9 of the WBGST Act 2017 has been passed without appreciating the provisions of section 16 within bracket 5 of the WBGST Act 2017. The petitioner has filed an application praying for rectification. Order date ta boleche ki order under section 73(9) dated করে দিন ওখানে August 28, 2024. ঠিক আছে? The petitioner has filed an application under section 148
my lord.
of the WBGST Act 2017 for rectification of the aforesaid order dated August 28, 2020.
One short indulgence. Kindly come to page number 34 of my narrative petition.
Yes.
Paragraph number 3.2, my lord.
Yes.
It's clearly mentioned about the entire procedure, my lord, where demand show cause notice under section 73 or section 74 CGST Act has been issued, but no order under section 73 or 74 Act has been issued by adjudicating authority. In such case, the adjudicating authority shall take cognizance of subsection 5 or subsection 6 of the section 16 of the CGST Act, inserted retrospectively with effect from 1/7/17 and pass appropriate order.
Alright, so the কি বললাম? Uh, 28th of August 2024, but no decision on such application has been taken, and keeping such application pending, where is the demand notice?
At the last notice at page number 46, my lord.
And keeping such rectification petition pending, a notice dated October 30, 2025 has been issued
Recovery. It's a recovery notice, my lord.
For recovery of the amount of tax, interest, and penalty. Full stop. Paragraph. The learned Ms. Sarkar, learned advocate appearing for the Mr. Shah, learned additional government pleader assisted by Ms. Sarkar appears for the state. Full stop. She submits that the order under section 73 within bracket 9 of the WBGST Act was passed after considering, was passed in accordance with law. First off, she further submits that the order passed under section 73 within bracket 9 is an appellable order, and the petitioner has not approached the appellate authority. Full stop. Paragraph. Heard the learned advocates for the respective parties and peruse the materials placed. Full stop. The learned advocate, the question that arises for consideration is whether the order passed under section 73 within bracket 9 of the WBGST Act was passed after considering the relevant provisions of the 2017 Act and the circular dated October 15, 2024, issued by the Government of India, Ministry of Finance, Department of Revenue, Central Board of Indirect Taxes and Customs. Full stop. Since a rectification petition has been filed highlighting the aforesaid issues, this court is of the considered view that interest of justice would be subserved if the, which authority will decide that? If
Well,
the
the authority
concerned
itself who has
respondent
issued, that
authority is directed to,
Deputy
uh,
Commissioner. No, it was the Senior Joint Commissioner.
consider the rectification petition and to dispose of the same
Senior
within
Joint Commissioner.
a stipulated time frame. Full stop. In view thereof, who will decide?
The Senior Joint Commissioner.
Which in view thereof, the Senior Joint Commissioner of State Tax, Siliguri Circle, being the first respondent, is directed to consider the revision petition filed by the petitioner dated.
Rectification, Lordship, not revision.
Rectification, my lord. Under section
Sorry, revision, not revision. Rectification petition dated. Where is the date?
3/4/2025.
Filed on 3/4/2025.
Yes, my lord.
3rd of April 2025. In accordance with law, after giving an opportunity of hearing to the petitioner or his authorized representative, and by passing a reasoned order which shall be communicated to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 3 weeks. Within a period of 4 weeks from the date of receipt of a server copy of this order. Full stop. There shall be an order of stay of operation of the respondent authorities are restrained by an order of injunction from giving any effect to and or further effect to the notice dated October 30, 2025.
Not to freeze my amount, my lord.
Not to give any effect to this notice.
Obliged.
Not to give any effect or further effect to this notice till 2 weeks after the communication of the decision on the rectification petition.
Obliged.
So you will be getting 2 weeks more.
Yes, my
if
lord.
you want to.
Well, actually, they issued this order by violating section 16, subsection
If you
5.
succeed, you succeed. If it is against you, you get 2 months breathing time. Sorry, 2 weeks breathing time to take.
To file appeal, my lord, I need to file appeal, my lord. To be honest, I need to pay money and then go for the appeal. So
That's a different thing. So 2 weeks.
that's why
breathing
section
time,
148 application was.
আবার দেখে কি হবে?
My lord, may I get back my book?
Book, yes.
Yes.
Lordship deeply obliged. And we are lucky to have